Good morning and welcome to the March 25th, 2021 Arizona Board of Pharmacy meeting. My name is Lori Walmsley and I'm the president of the board. I'll call this meeting to order at 8:30 a.m. Dr. Gandhi, can you take the roll to establish a quorum?
Thank you, Madam Chair. Mr. Solari?
At your service.
Mr. Dang? Mr. Dang? I did not see him. Mr. Minkus?
Here.
Okay. Mr. Leyba?
Morning.
Ms. Lehan?
Present.
Ms. Walmsley?
Here.
Mr. Tong?
Present.
Mr. Goodman?
Virtually present.
Thank you, Mr. Goodman. Ms. Snare?
Here.
And going back to Mr. Dang.
It looks like he's having connectivity problems. Perhaps the staff should reach out.
Yeah, we'll do that.
Thank you. Mr. Harris, point of order, can I take all the items in 25 together?
Madam President, you may.
Okay, thank you. Items 25. This is the time for the board to consider consent agenda items 25A through 25E. Reed Alexander Miller, board case 20-0511. Alberto Valle, board case 20-0503. Tristan Baker, board case 20-0201. Dominique Monet Harris, board case 20-0324-PHR. Oscar Augustine Lopez, board case number 20-0388-PHR. Are any of the respondents present today?
Madam Chair, just for the record, Mr. Dang has logged in.
Thank you. Dr. Gandhi, do you see any of these respondents present?
I do not, Madam Chair.
Thank you. Does any respondent, attorney, or board member want to pull any case from the consent agenda for further discussion? Hearing none, will the state's attorney please introduce themselves?
Seth Hargraves, Assistant Attorney General on behalf of the state.
And this is Jean Galvin, Assistant Attorney General. Mr. Hargraves will be handling these motions to deem.
Thank you, Ms. Galvin. Are there any other parties present for this matter? The state has filed a motion to deem and vacate the hearing in each of these matters. If these motions are granted, the board will have adopted the factual allegations set forth in the complaints and the findings of fact and the alleged violations of law as its conclusions of laws. Is there any motions regarding the state's motions to deem? Board members, do we have a motion?
Madam President, I will make the motion to grant the state's motion to deem and vacate the hearing.
Goodman, second.
Thank you. I have a motion and a second. We will now deliberate on, any further discussion? Dr. Gandhi, do we need a roll call for this?
No, Madam Chair.
Okay. All those in favor?
Aye.
Any
Aye.
opposed? Hearing none, we'll now deliberate on the appropriate discipline to be imposed. Board members, do we have any discussions or a potential motion?
Madam President.
Go ahead, Mo.
Madam President, since there's no discussion, I move to adopt the state's recommended discipline as set forth in its motions to deem and vacate the scheduled hearings. I believe their recommendation was to revoke the licenses of these individuals.
Second.
Thank you, Ms. Snare. I have a motion and a second. Any further discussion on these matters? Dr. Gandhi, can you take a roll call, please?
Certainly. Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leyba? Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
and Ms. Nair.
Aye.
Motion carries. This concludes these proceedings. The board's decisions will be reduced to written orders, which will be sent to each of the respondents. Thank you for your attendance today. Item number 26, 26A. This is the date and the time and the place where the matter involving Derek Johnson relying board case number 20-0324 PHR scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine if there have been violations of the board statutes, rules, and whether disciplinary action is warranted. Board members present today include Lori Walmsley, Kristen Snare, Joe Leba, Kevin Dang, Ruben Minkus, Mohammed Salari, Theodore Tong, Cedar Lehan, and Nick Goodman. Let the record reflect that the board members have been furnished copies of the complaints, notice of hearings, and all pleadings of records. Will the parties please introduce themselves, starting with the state?
Seth Hargraves, Assistant Attorney General.
Jean Galvin, Assistant Attorney General. Mr. Hargraves will handle this matter.
Mr. Hargraves, I believe we don't expect to see Mr. Relying today.
No, this case was set for hearing. Mr. Railing did not timely notify the board of criminal charges. The board had voted to offer him standard consent agreement for a $250 civil penalty. He did not respond, so the matter was forwarded to today's hearing. After the notice of hearing was sent out, he did sign and return the consent agreement, which is in your packet. Given that the signed consent is consistent with past board actions for this conduct, the state would ask that you would accept the consent agreement to resolve this case in lieu of the hearing.
So to vacate the hearing and accept the signed consent agreement?
Correct.
Okay. Board members, do we have any discussion, or do we have a motion to accept the proposed consent agreement and to vacate the hearing?
Goodman, I propose that we accept the signed consent agreement and vacate the hearing.
Thank you, Mr.
Second.
Goodman. Thank you, Mr. Leba. Any further discussion? Dr. Gandhi, I believe this one will be a roll call.
Yes, it is, Madam Chair. Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
and Ms. Nair.
Aye.
Thank you. This concludes this proceeding. A fully executed copy of the consent agreement will be sent to all parties. Thank you for attending this hearing. Item 26B, Lisa Lee, board cases number 19-0446 and 20-0471. This is the date and the time where the matter dealing with Lisa Lee, board cases number 19-0446 and 20-0471 is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to be determined if there have been violations of the board's statutes and rules and whether disciplinary action is warranted. The board is committed to ensuring that business is conducted in a respectful manner. When conducting formal administrative hearings, the parties are expected to treat the board, witnesses, and each other with respect and in a civil and courteous manner. These parties shall not engage in any conduct that brings disorder or disruption to this proceeding. Neither party shall be allowed to interrupt the board or the opposing party except where necessary to make an effective objection. If the party does not adhere to these basic civilities, the board will be asked to modify the board will ask the party to modify their behavior. If the party continues to exhibit disruptive behavior, the party's microphone will be muted until it is their turn to speak. Board members present today include Lori Walmsley, Kristen Snare, Joseph Leba, Kevin Dang, Ruben Minkus, Mohammed Salari, Theodore Tong, Cedar Lehan, and Nick Goodman. The records reflect that the board members have been furnished copies of the complaint and notice of hearings and all records and all pleadings of record.
Madam Chair,
Yes.
Sorry to interrupt you, but I'd like to announce my recusal.
That's correct. Thank you. Let the record reflect that Mr. Label will be recused from this discussion today. Will the parties please introduce yourselves?
Jean Galvin, Assistant Attorney General on behalf of the state.
Thank you, Ms. Galvin.
I believe Ms. Lee is present online.
Yes, I am.
Ms. Lee, can you please introduce yourself for the record today?
My name is Lisa Lee, and I'm a pharmacist, and I'm here for my hearing.
Thank you. Ms. Lee, do you have an attorney today?
No, I don't.
Okay. You have the right to be represented by an attorney, but the law does not provide for the appointment of counsel on your behalf. If you want an attorney, it is your responsibility to secure and pay for one. By proceeding without representation of legal counsel, you are waiving your rights. This hearing is the opportunity for you to present testimony and evidence on your behalf. And if you appeal the board's decision, the record you make at this hearing today will be evidence considered in court in determining whether the board's decision was proper. Do you understand what I've told you, and do you wish to proceed today without counsel?
Yes, I do.
Thank you. A hearing of this nature differs from a court proceeding. The technical rules of evidence do not apply. Reliable hearsay evidence is admissible. The board will entertain concerning irrelevant, repetitious, or otherwise inadmissible evidence. Each party will be allowed to present evidence and cross-examine opposing witnesses and make a closing argument. In a disciplinary proceeding, the state bears the burden of proof and shall present its case first. Each party will now make an opening statement. This is a brief summary of the case that you intend to present today. Does the state wish to make an opening statement?
Yes, briefly. Thank you, members of the board. The mission of the Board of Pharmacy is to protect the health, safety, and welfare of the citizens of Arizona by regulating the practice of pharmacy. The board accomplishes its mission in part by issuing licenses to qualified applicants and disciplining those licensees who have committed unprofessional conduct. The case before you today involves Ms. Lisa Lee. She is a licensed pharmacist. You will hear from Director Cam Gandhi that he will testify today that Ms. Lee requested a formal hearing relating to her 4 instances of unprofessional conduct. First, the board learned from the Board of Osteopathic Examiners that Ms. Lee caused a disruption at a physician's office and was cited for disorderly conduct. Ms. Lee failed to disclose to the board that she was charged with 1 misdemeanor count of disorderly conduct within the statutory timeframe. This offense occurred on October 4th, 2018 in Chandler. Pursuant to ARS 32-3208, Ms. Lee was required to report the charges to the board within 10 days, and she failed to do so. Secondly, just 3 weeks after the criminal incident, Ms. Lee filed her application for renewal and answered no to the question of whether she had been arrested since her last renewal. The evidence will demonstrate that this was a false answer. Third, during the board's investigation of Ms. Lee's criminal incident, Dr. Gandhi will testify that his staff discovered that Ms. Lee had failed to complete the required CE for the last 2 renew cycles. She is deficient 60 hours in continuing education. And finally, on her applications for renewal in 2018 and 2020, Ms. Lee attested that she had in fact completed her continuing education requirements for the previous 2 years. Again, the evidence will demonstrate that she made a false statement on those 2 applications. At the conclusion of the proceeding, the state requests that you find Ms. Lee's conduct in violation of 32-3208, 32-1901.01B7 for failing to comply with the continuing education requirements established by the board, and 32-1901.01B19, which is violating or attempting to violate directly or indirectly in the violation of any part of the Practice Act contained in 32-1932-6, which requires pharmacists to satisfactorily complete continuing education requirements. as well as violating Arizona Administrative Code R4-23-204 relating to the completion of continuing education hours and the maintenance of records of those CE hours. And finally, the state would ask at the conclusion of its presentation of evidence that you find Ms. Lee violated 32-1901.01 B17 for knowingly filing with the board any application, renewal, or other document that contains false or misleading information. At the conclusion of the hearing, the state requests that you impose a stayed revocation against Ms. Lee's pharmacist license, that you order her to pay $100 per CE credit that she did not complete for a total of $6,000 payable in 90 days, and that she be required to complete 1.5 times the number of CE hours the next renewal cycle, and that she be automatically subject to undergo an audit. Thank you.
Thank you, Ms. Galvin. Does the respondent wish to make an opening statement?
Everything that I wanted to say, I've already said it in my response, in my required written response to you guys that was sent on March 10th of 2021. And from what I've said, there were reasons why I was not able to notify you guys in time at that time because I was severely distraught. And I did complete my CEs, but there's no way for me to prove it because unfortunately it was not recorded. And so when I filed for my renewal, I was not lying, I was being honest, but unfortunately there is no way for me to prove that that was the case. And I'm requesting that I'm willing to pay for the fines, the $250 fine and also the $6,000 fine. But if you can minimize the $6,000 fine, because I've not been working for a while and take that into consideration. And also allow me to extend the time frame to pay the fines from 90 days to a year, then I would really appreciate it. And I would really thank you for your support and consideration due to my circumstances.
Thank you, Ms. Lee. Does the state wish to call witnesses?
Yes, one witness today, Dr. Cam Gandhi.
Court reporter, can you please swear in the witness? Do we have a court reporter today?
No, that would have to be Jennifer Kay that would swear me in.
Jennifer?
Yes.
Can you please swear in the witness?
Yes. One moment, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Dr. Gandhi, could you please tell us for whom you work?
The Arizona State Board of Pharmacy.
And what position do you hold and how long have you held it?
I am the executive director of the Arizona State Board of Pharmacy and been in my position for almost 6 years now.
And you're a licensed pharmacist, correct?
I am, yes.
Through your employment as the board's executive director, are you familiar with Miss Lisa Lee?
I am, yes.
She's also a licensed pharmacist, is that correct?
That is correct.
You have received, and all board members have received, and Ms. Lee has received a copy of the state's proposed exhibits. Could you please refer to what has been marked for identification in state's exhibit number 1 and identify that document for us?
That is a license issued by the Board of Pharmacy to Ms. Lisa Lee.
And when does that license expire?
3/26/2021.
It has been extended for the purpose of conducting this hearing, is that correct?
That is correct.
And could you just briefly tell us what the allegations against Ms. Lee are?
The allegations are not informing the board in a timely manner of being charged, as well as not completing continuing education credit in essence, misleading the board on an application for renewal.
Please refer to what has been marked for identification as State's Exhibit Number 2 and identify that document for us.
That is a document that was sent over by the Arizona Board of Osteopathic Examiners on November 8, 2019.
And is this the letter that prompted the opening of the complaint into Ms. Lee?
Yes, that's correct.
And what does the letter tell us?
At the request for the board, the enclosed case file is referred to the Arizona State Board of Pharmacy. The Arizona Osteopathic Board medical consultant reviewed the case and notes the complainant claims to be a pharmacist and appears to be engaging in drug-seeking behavior.
And as you investigated, what was the nature of the incident that prompted the osteo board to notify the board about Ms. Lee?
It seemed to have stemmed from an altercation at a medical facility where Ms. Lee was present. Local authorities were called because of a disruption.
And was she ultimately charged with disorderly conduct?
Yes, she was.
And is she required to report those criminal charges to the board?
She is, yes.
And is that pursuant to ARS 323208?
Yes, it is.
And what does the statute require of a healthcare professional who has been charged with criminal offense?
Notify the board of the charge within 10 days.
Does your staff notify Ms. Lee about?
I'm sorry, can I ask a question? I heard Ms. Jean Gavin said criminal theft.
Ms. Lee, you'll have a chance to object, or do you object to that statement?
Yeah, I object. Yes, I object to if she said criminal theft. If that's what I heard, then I guess I object to that.
Mr. Harris, is that appropriate?
I said criminal offense.
Yeah, you may want to hear from the state.
Ms. Galvin?
I asked Mr. Gandhi about the criminal offense, the criminal charges.
Okay, I heard you said criminal theft. All right.
Okay, thank you.
Dr. Gandhi, does your staff notify Ms. Lee about the criminal charges and the opening of the complaint against her because of those charges?
Yes, we did.
Would you please refer to what has been marked for identification as State's Exhibit Number 3 and tell us what that document is?
That is a document, an email that was sent to Ms. Lee informing her of a complaint being opened.
And does it make any requests of Ms. Lee?
It informs her we were in receipt of and known about her arrest, and then requests that she submit documents to us.
And does she respond to that request for information?
It looks like she does not.
Does your staff eventually send a subpoena to Ms. Lee for the information?
Yes, we did.
Please refer to what has been marked as Exhibit Number 4. And does this appear to be a response and a copy of the subpoena that was sent to Ms. Lee from your staff?
Yes, it is.
Does it also contain a cover letter from Ms. Lee and a written narrative?
Yes, it does.
And it also appears to contain a certificate of completion for anger management and police reports. Am I summarizing that correctly?
Yes, you are.
Okay. Members of the board, I want to make a disclosure at this time. When Ms. Lee responded to the subpoena, she also included medical records from a visit to the ER after her arrest. But the state did not include those records as part of this exhibit, even though they were submitted as part of the subpoena, because they are medical records. The state did not deem them relevant, and I did not want to put confidential medical records into an administrative record when they are unnecessary, even though she did provide them. So I'm just making that disclosure. This wasn't she didn't have a complete response to the subpoena, but I did not include the medical records. So I would just like the board to understand that. Did Ms. Lee, in this Exhibit Number 4, provide a written narrative of her account of the story?
Yes, she did.
And could you briefly And I believe that's on page 3245. Could you briefly just give us a summary of her written narrative?
Ms. Lee indicated she is not working. She was wrongfully arrested, assaulted by Chandler police, severely discriminated against, discriminated, belittled, yelled, used profanities against her. She thought by state law that her rights were violated and her HIPAA rights were violated as well. She suffered from a really bad head injury. Conclusion. The copy is sort of faded. She has not been herself or normal and has loss of memory, could hardly recall or remember anything. Also suffered from certain medical conditions that we won't get into further.
Can we refer to exhibit number 5? And could you identify this document for us?
This is the statement. I'm sorry, exhibit number 5.
Yes.
Certainly. It is a court case detailed information.
Okay, and that shows us what she was charged with?
Yes, it does.
And is it your understanding that the charge was eventually dismissed after she completed a diversion program?
Yes.
This matter occurred on October 4th, 2018. Is that correct?
That is correct.
All right, will you please look at what has been offered for identification, Estates Exhibit number 6, and identify that for us?
Those are questions from our renewal application.
And is this Miss Lee's renewal application?
Yes, it is.
And for what she signed it or submitted?
Correct.
Did she submit it on October 31st of 2018?
Yes, she did.
And this is just a few weeks after her criminal incident, is that correct?
That is correct.
Do any of these questions on the application ask the applicant to disclose any criminal arrests?
Yes, question number 2.
And what, you can just read that, the first sentence. What does that question ask the applicant?
Since you last renewed this license, have you been arrested for, charged with, pled guilty to, or no contest to, or been convicted of a felony or misdemeanor offense?
And how does Ms. Lee answer that question?
Ms. Lee answered no.
And at the bottom of this application, does she check the box where she declares under penalty of perjury under the laws of the state of Arizona that the information she's provided in this application is true and correct to the best of her knowledge?
She does.
So would her answer of number 2 be a true and correct answer?
That's correct.
Is her answer correct in number 2 or is it a false answer?
It is a false answer.
I would move, Madam Chairman, exhibits 1, 2, 3, 4, 5, and 6 into evidence, please.
Madam Chair, I'll make a motion to accept the exhibits provided by council into evidence.
And Madam President, before entertaining the motion, you may want to hear from the respondent to see if she has any objections to any of the exhibits identified by the state at this time.
Thank you, Mr. Harris. Ms. Lee, do you have any objections to any of the documents provided by counsel?
Were these the documents that were emailed to me earlier? Because I'm not seeing anything on the screen.
I believe so.
They were emailed to you, Ms. Lee.
I mean, am I objecting to it? I mean, I don't agree with the police reports, and with some of the accusations, but the documents are what they are, so.
Are we able to proceed, Mr. Harris?
Yes.
Okay, so I have a motion. Do I have a second?
Yeah, I second it.
Okay, all those in favor?
Aye.
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 Mr. Gandhi, we will continue on. Your staff is investigating Ms. Lee's criminal charge and her failure to disclose to the board. And that's moving through the investigative process when Ms. Lee then files her application for 2020 renewal. Is that correct?
That's correct.
Please refer to it has been marked for identification states exhibit number 7. And just identify that document for us, please.
That is a paper renewal application.
Okay, and when was it filed?
It was filed October 30th, 2020.
And we see that on the second page of the document, is that correct?
I'm sorry, it was post-stamped November 3rd, 2020, but Ms. Lee signed it on October 30th, 2020.
Okay. At the bottom of that second page, there's an attestation. And what does that attestation relate to?
The attestation relates to, and I can read it by signing below, I certify that I have complied with the continuing education requirements set forth in ARS 32-1925, 32-48.02, and AAC R4 23204, including the opioid-related substance use, motor-related or addiction-related continuing education requirements.
Okay, and a pharmacist on renewal must have completed 30 hours over the 2-year period, is that correct?
Yes, up to the point of renewal, yes.
Okay. Your staff receives this renewal application, the attestation by Ms. Lee that she completed the required number of hours for renewal. And then what does your staff do after that?
The staff requests, one moment.
Do they check the CPE monitor?
They do.
And could you tell us what the CPE monitor is?
Sure, it's a database that, if it's an ACP accredited CE, it's a database that collects that information in a central location for accurate record keeping.
And so this monitor tracks all of a member's CE for a number of years, and your staff has access to that database, is that correct?
That is correct.
Okay. And that's just for Arizona licensees, is that correct?
That's correct.
Let's look at.
I'm sorry, Ms. Galvin. CPE Monitor is a nationwide database, but we in Arizona have access to only folks that are licensed in Arizona.
Okay, thank you. Let's start with exhibit number 8. And it appears to be emails between different members of your staff, correct?
Correct.
And these emails just notify that one of your staff members notifies a supervisor that they checked the CPE monitor and it shows no CE for Ms. Lee for the last 2 renewal cycles. Is that correct?
That is correct.
Okay. And then exhibit number 9 is what, please?
Exhibit number 9 is communication with Ms. Lee.
Okay. On the second page of that submission is an email from Ms. Lee to one of your staff members. Does she explain her failure to complete the CE, or how does she inform your staff that she has not completed the CE?
She emails my deputy, Jennifer Gilnavong, and the top part of page 2 is, I understand that you want me to send you a list of all my completed CEs for 2 years prior to my license expiration, and had given me a deadline. I just want to be sure I understand exactly what is it you want. Let's just say, for instance, if I wasn't able to complete all my CEs with those timeframes, since I was hospitalized and pretty ill, what are the options? That's what she was asking.
So she seems to suggest to your staff that in fact she did not complete the CE. Is that correct?
That was inferred, yes.
Let's look at exhibit number 10. And what is that document, please?
The first page of that document informs Jennifer Mitchell to open a complaint for failure to complete the CE.
And on the second page, is there an acknowledgement from Ms. Lee that she can't find her CE documents at this time, and she does not have all of the 30 hours of CEs completed? Is that correct?
That is correct, and that was sent to us November 10th of 2020.
I would move exhibits number 7, 8, 9, and 10 into evidence, please.
Ms. Lee, do you have any concerns with any of the exhibits that the state is providing?
All right, are you asking me?
Do you object to any of the exhibits provided by the state?
No.
Thank you. Do I have a motion?
Madam Chair, I'll make a motion to admit those exhibits into evidence.
Thank you. Do I have a second?
Second.
I'll second.
Thank you, Mr. Dang. I have a motion and a second. All those in favor?
Aye.
Aye.
Any opposed?
Dr. Gandhi, you mentioned this CPE monitor. Would you please look at exhibit number 11? And could you tell us what this document is?
That is a report from the CPE monitor activity. It's a transcript.
Okay, and who does it relate to?
This is related to Miss Lisa Lee.
And what is the time period?
The activity date range was from November 1st, 2010 to 11/3/2020.
So this would show us the CE that Miss Lee took between that time period. Is that correct?
That is correct.
What is the last date, according to this document, that shows Miss Lee had completed CE?
The last activity date we have is dated September 21, 2016.
So there was no CE taken in 17 and 18, is that correct?
That's correct.
Can we go back to exhibit number 6 that was admitted into evidence, Dr. Gandhi? And the board will recall that this is a renewal application for Miss Lee, and it's dated 10 of 2018. What does Miss Lee attest to on this document about her CE requirements?
Question number 3 on the renewal asks if you've complied with the statutes and rules around CE, continuing education requirements. And Ms. Lee answered yes.
And is that a true and correct answer?
No, it is not.
And the evidence shows that the CE monitor has no record of her completing any CE during this requested time period. Is that correct?
That is correct.
If we look at exhibit number 9, that has already been admitted into evidence. I'm sorry. Exhibit number 7. This is her paper renewal for 2020, is that correct?
That is correct.
And the question number, the attestation on the second page relates to CE, is that correct?
That is correct.
And she, by signing, attests that she had completed the CE. Is that a truthful attestation?
It is not a true attestation, no.
If you would please refer to what has been marked for identification as State's Exhibit number 12. Could you identify that for us?
That is a CP monitor activity transcript report with a narrower date range.
And this is, I'm sorry, go ahead.
No, go, I'm sorry.
This is for Miss Lee, is it not?
That is correct.
And the date range specifically covers the renewal period for 2020?
Yes, it does.
And what does it show with respect to her activity?
There was no activity.
I would move exhibits 11 and 12 into evidence, please.
Ms. Lee, do you have any objections to any of these exhibits as provided by the state? Ms. Lee, do you have any objections? Mr. Harris, are we free to proceed without a response?
No, that's fine.
Okay, thank you, Ms. Lee.
Sorry.
I appreciate that. Board members, do I have a motion regarding these exhibits?
Madam Chair, I'll make the motion to admit these exhibits into evidence.
Second.
Thank you. Do I have a second? Thank you, Mr. Dang. I have a motion and a second. All those in favor?
Aye.
Aye.
Any opposed?
So Dr. Gundy, the board then opens a complaint against Miss Lee for her failure to complete the CE, is that correct?
That is correct.
And do we see that notification to Miss Lee in exhibit number 13?
Yes, we do.
Okay, and at the page, she requests this formal hearing about this complaint, does she not?
Yes, she does.
If you refer to what has been marked for identification of State's Exhibit number 14, is that the complaint and notice of hearing that was issued in this matter?
Yes, it is.
I would move exhibit 13 and 14 into evidence, please.
Ms. Lee, do you have any objections to either of these exhibits?
No, I don't.
Thank you. Board members, do I have a motion?
Yes, ma'am. I'll make the motion to admit these exhibits into evidence.
And I
Thank you.
second.
Thank you. All those in favor?
Aye.
Aye. Any opposed?
Okay, Dr. Gandhi, we have the 4 issues before this board today of Miss Lee not timely reporting her arrest, not disclosing her arrest on the renewal application in 2018, lying on both her 2018 and her 2020 renewal application about completing the CE, and her failure to complete the CE. What is it that the board is seeking today in terms of discipline against Miss Lee?
Board staff would like to see Ms. Lee agree to the consent agreements issued through an order, and if not complied with, then revoking her license based on not complying with the educational requirement required to maintain and support her ability to take care of patients in Arizona.
To be more specific, the consent agreement previously offered called for $100 per credit hour of CE that she is delinquent, and that turns out to be 60 hours of CE for $6,000, a specific time within which she has to pay, a completion of 1.5 times the regular CE hours this current renewal cycle, and an automatic audit. Is that correct?
That is correct.
And this, you had mentioned a revocation, so this would be a stayed revocation. If she failed to comply, then the stay would be lifted and her license would be revoked.
That is correct.
Thank you.
In addition, Ms. Galvin, as there was also a failure to notify the board of a charge,
yes,
would also need to be addressed.
And what is the board seeking for that failure to notify?
The normal customary consent agreement would have been $250. I believe that was issued. And we seek for that to be in an order form as well.
All right, thank you, Mr. Gandhi. Madam Chairman, members of the board, the state has nothing further and we would rest.
Thank you, Ms. Galvin. Ms. Lee, do you wish to cross-examine the witness?
Mr. Gandhi, I just have a question. I did not, when I was sent the first request for the information, I did not receive the email, and or else I would not have not responded right away. So I just want to put that out. Also, I understand where you guys are coming from, and I accept my responsibility about not being able to provide you guys with the proof that I've completed my CEs. So I understand that is my responsibility to take. And so,
I'm sorry, Ms. Galvin.
I would ask that you instruct the respondent to either ask questions of Dr. Gandhi or proceed with her case in chief, but she is testifying at this point rather than conducting a cross-examination.
Thank you, Ms. Galvin. Ms. Lee, do you have any specific questions for Dr. Gandhi?
No, I don't.
Okay, thank you. Board members, do you have any questions? Ms. Galvin, do you rest your case at this point?
Yes, nothing further, thank you.
Thank you. Ms. Lee, do you have any witnesses to call today?
No, I don't.
Do you wish to rest your case at this time?
No, I just want to make a statement. I just want to make a statement before I rest my case.
Mr. Harris, is that appropriate? Mark, you're on mute.
I'm sorry, Madam President, members of the board. Yes, you can afford her an opportunity to, in essence, use her time to present her case through a statement.
Okay, thank you. Ms. Lee, please proceed.
So I understand the charges that are against me, and I accept my responsibility that I was not able to provide the information that you guys requested. So I understand where you guys are coming from, but I just want you to understand where I'm coming from as well. And all the stuff that I want to say has been provided to you guys through my written response that was emailed to Mr. Gandhi on March the 10th of 2021. All that I'm asking is that you will afford me the time to pay for my fines in a longer time frame, so that I can pay for the fines, because I've worked really hard all my life to get my license, and I don't want to lose my license because I still love to help people. And by allowing me to extend the time to pay my fines to a year, that would really help me to get my life back, to restart my life again. And in order to keep my license, because I've worked really hard for my license all my life, and I don't feel that it's fair for me to lose my license because I don't have the funds to pay for the license within the minimal time frame that you guys are requiring me to do it in. So basically, what I'm asking is that for you to allow me to pay for the fines in more time, within a year, instead of the minimal 90 days that I have. And that's all that I have. Thank you.
Thank you, Ms. Lee. Board members, do you have any questions? Ms. Lee, yes, go ahead.
May I ask Ms. Lee a question?
Yes.
I want us to refer to Exhibit 11, which is page 3368 of the board book. Ms. Lee, before 2016, you were routinely documenting all your CEs on the monitor, on the CPE monitor. Please help me understand what happened after 2016, where you stopped having your CE documented on the CPE monitor.
I don't know what happened, but some of the CEs that I was taking was not part of an online program. or whatnot. And so some of them were seminars, some of them were done through other programs that was not automatically recorded with the CPE, like Power Pack or those other online pharmacist letters and those sort of things. And so some of them were not recorded accordingly. So unfortunately, when my house was flooded, a lot of those were just documents that I had printed out that I lost, and there was no way for me to retrieve those documents.
I hate to, you know, I'm a pharmacist too, and I've done CE through both Power Pack and pharmacist letter. Both of those report those. I'm willing to show you my CPE monitor, and it's full of CE by these guys and have been reported. I just can't see that being correct.
I'm saying that those avenues were recorded. I'm saying that those other avenues that I had taken my CEs and were not recorded electronically. So I think you misheard me.
Very well. Thank you, ma'am.
Thank you.
Board members, any additional questions? Hearing none, Ms. Lee, do you wish to rest your case at this time?
Yes, I do.
Thank you. This concludes the evidentiary portion of the hearing. The board will now hear closing comments. The state do you wish to make a closing comment?
Yes, a brief closing argument, members of the board. The evidence presented today establishes by a preponderance of the evidence that Ms. Lee, licensed pharmacist, has committed unprofessional conduct and is therefore subject to disciplinary action. The facts presented demonstrate that she was charged with a criminal offense and that she failed to inform the board of that pending charge in violation of ARS 323208. Not only did Ms. Lee fail to notify the board of this criminal incident, she lied on her renewal application when asked about arrests or charges just 3 weeks later. During the pendency of the board's investigation into the criminal offense, the board discovered that Ms. Lee had not completed continuing education for the past 2 renewal cycles. Not only is she deficient in the 60 hours, but again, she lied on 2 applications for renewal when she attested that she had completed the hours. Her story continues to evolve. First, she suggests to the board that what if she didn't complete her CE? Now there's a house flood. Now she took CE from different sources that weren't recorded on the monitor, which if you do look at that exhibit 11, I believe it is, it shows her CE for all of those years. There are several that she took from the pharmacist letter that are recorded. The state respectfully requests that you issue a stayed revocation against Ms. Lee's license, order her to pay a civil penalty in the amount of $6,000, a $250 civil penalty for failing to report under 323208, that she be required to complete 1.5 times the hours required for this current renewal cycle, and that she automatically undergo a CE audit. If she fails to comply, the state requests that you would automatically lift the stay and that her license would be revoked and she would be required to apply anew once she complies with the board's order. If the board orders or grants the request pursuant to the stay, that would imply renewing her license. She does have a pending application. Her date to extend that license until it expires goes until today, or I believe maybe tomorrow. And then if you grant the board's request, the application for renewal would be granted, but there would be an automatic stayed revocation applied, and then she would have to comply as the state requests with CE and the civil penalty, etc. Thank you.
Thank you, Ms. Galvin. Ms. Lee, do you wish to make a closing argument?
Yes, I do. I did not make any false. At that time, when I renewed my license, like I said before, I was severely distraught due to being assaulted by the Chandler police. I did go to the hospital. I did receive medical treatments from the injuries that had resulted from me being assaulted, and I suffered from PTSD as a result of what happened to me. And I did not intentionally mislead or falsify any documents because at that time my head was not thinking of anything else because of my because of being mentally distraught. I'm not I know that you think that I'm making excuses for my actions, but I'm not trying to make excuses for my actions. I'm just trying to be as honest as I possibly can. All the things that I've said today and that I've written in the documents, I've already brought it up to you guys at previous hearings, at previous Zoom meetings, and those kind of stuff, and those kind of things. And so it's nothing new that you're hearing today that I've not mentioned earlier. There was a house flood at my house. It did happen. And so it would be stupid for me to make up lies and excuses of things like that, of things that didn't happen, that did happen. So I'm not making any excuses. Everything that I've stated before and that I'm saying now in writing and verbally to you guys are true and accurate to the best of my knowledge. And at the time that it happened, at that time I was not thinking, my head was not in the right place. And that's why those things happen, but I did not intend on misleading or falsifying any kind of documents to anybody. And I just want to be clear about that. Thank you.
Thank you, Ms. Lee. Ms. Galvin, do you wish to make a brief rebuttal?
Nothing, thank you.
Thank you. Board members, it's time for us to discuss or entertain motions regarding the findings of fact, conclusions of law, and a final order.
Madam Chair, may I be allowed to ask Ms. Lee one more question?
Mr. Harris, is that appropriate?
It is at the president's discretion.
I
Go
don't
ahead,
have
Ms.
an objection.
Okay, thank you, Ms. Galvin. Go ahead, Mr. Solari.
Ms. Lee, you have known that you're going to have to make up the 60 hours of CE that you were deficient or you were unable to provide proof of. Have you started doing any of the 60 hours of CE that you were deficient for the past 2 cycles?
Yes, Mr. Solari, thank you for bringing that up. I thought that I know that I'd already written it back, had responded per the writing. But since you brought that question up, yes, I did complete 33 required CEs, sometimes around December of last year. Despite it being after my renewal expiration of October the 30th of 2020, I was still able to complete the 33 required CEs, more than the 30 that I needed on about December 20th of 2020. And so I would like for you guys to take that into consideration as well. In this
documentation, are those going to show up on your CPE monitor now, or do you have
that? Yes, they did. Yes, they did. After I was able to move back into my house and regroup everything, and then get my life back on track, I was able to do everything and document everything, knowing how vital it is, irregardless of what the circumstances. Yes, thank you for bringing that up.
Thank you, ma'am.
Board members, additional discussions or thoughts on a motion?
Madam President,
Yes.
given the fact that Ms. Lee is having financial difficult hardship during this time, would it be possible that we can extend the payment period to a year? That she is to pay the $6,000 over a year period?
Mr. Dang, could I have Ms. Galvin go over the 2 different options that she had mentioned before we discuss that?
Sure.
The state has requested that you impose a stay of a revocation, that Ms. Lee be ordered to pay essentially a $6,000 civil penalty for the CE that she did not complete timely, a $250 civil penalty for failing to disclose her criminal charge. Whether she's required to pay that in over a period of 90 days or 12 months, the state's going to leave that to the board's discretion. The state understands that there are a number of individuals having financial hardships at this time. We just request that she be held responsible for failing to comply with the CE, for failing to notify the board of her criminal charge, and for lying on her applications. Because of the failure to take CE and complete it timely, the state asks that the board be consistent and, as part of its order, require her to complete 1.5 times of the CE required for this next renewal cycle, and that she undergo an audit for this current renewal cycle. If she fails to comply with any of those terms, then the stay is automatically lifted and she would be revoked. So if she fails to pay the civil penalty in a timely fashion, then the stay would be lifted and she would be revoked until such time she does comply with your order.
Thank you.
Thank you, Ms. Galvin. I tend to agree with Mr. Dang. I do want to be consistent in the way that we've handled it, but this is also a very large fine. And I understand the economic realities of the circumstances that we're in today. So I would be in support of allowing the longer time frame to pay the fine.
Yeah, I agree with you, ma'am, as well. I think it's very reasonable.
Thank you so much, Ms. Wamley and Mr. Laurie and Mr. Dang.
Well, Mr. Dang, would you like to make the motion or should I? Or?
So if I can do that. So I make a motion to allow Ms. Lee to pay the civil penalty of $6,000, total of $6,250.
Mr. Dang, I think we're jumping a little ahead. We need to adopt the findings of fact.
Okay.
So let's, the board will now discuss whether the state has proven these allegations. Board, do you have any questions?
And for the board's reference, in exhibit number 14 is the complaint and notice of hearing that sets forth the factual allegations, the alleged violations.
Do I have a motion relating to the findings of fact?
Move that we accept.
Move to accept. So Dr.
Mr. Harris
Tom made a motion, I can second.
Thank you.
So, Madam President, members of the board, as I understand the motion, it is to adopt the factual allegations 1 through 14 as your findings of fact in this case.
Yes.
Thank you.
So I have a motion by Mr. Tong and a second by Mr. Dang. All those in favor?
Aye.
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 Is there a motion to adopt the factual allegations and alleged violations from the complaint and notice of hearings as no, we already did that. Findings of fact and conclusions of law. If the state, it's time to discuss the discipline.
Actually, Madam President, if we could entertain a second motion with respect to the conclusions of law, my understanding was the prior motion.
That was just
the findings of
that
fact.
was just the factual allegations. Okay. Do we have a motion relating to the conclusions of law?
Thank you.
I make a motion to that effect.
Law. Yeah, second.
All those in favor?
Aye.
Aye. Any opposed? And now moving on to the discipline. We have, go ahead.
I'm sorry, Madam President, just to confirm, the prior motion was to adopt the alleged violations 1 through 7 as your conclusions of law.
Correct.
Thank you. Thank you, Madam President.
Thank you.
I'm willing to make the motion then. I make a motion to accept the state's recommendation to stay the revocation, to fine $6,000 civil penalty for the incompletion of the CE, another $250 civil penalty on top of that for failure to disclose, 1.5 times the CE requirements, plus the automatic audit, as we've always done. And then if any of those, I'm sorry, the $6,000 and the $250 to be paid within 1 year, 12 months. If any of those requirements are not completed on time, then we remove the stay and revoke the license.
I second that.
Any further discussion, board members? Dr. Gandhi, I believe this one is a roll call.
Madam Chair, that would be Ms. Gail Navong that would have to do it since I was a witness.
Thank you.
Okay, Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Nay.
Mr. Leba. Sorry,
Recuse.
recused. Ms. Lahan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
Ms. Snare.
Aye.
The ayes have it.
Thank you. This concludes the proceeding. The board decision will be reduced to a written order. Thank you for attending. Ms. Lee, thank you for your attendance today.
Thank you so much. You guys have a wonderful day. Thank you so much.
Thank you. Board members, how are we doing on time? Do we want to proceed or does anyone need a brief bio break
I could use a break.
to regroup here? Okay. Let's come back at 9:45. Does that sound good to everybody?
Perfect.
Thank you. Thank you, Mr. Harris. Appreciate it.
You bet. Thank you, Madam President, members of the board.
Board members, welcome back. Dr. Gandhi, can you take attendance to establish a quorum, please?
Yes, Madam Chair. Mr. Solari,
Yes, sir, present.
Mr. Dang,
At your service.
Mr. Minkus,
No. Yes, here, I'm here.
Mr. Leva.
Here.
Ms. Lahan. Ms. Lahan. You're muted or something. I see you. Ms. Walmsley,
Here.
Mr. Tong.
Here.
Mr. Goodman. Mr. Goodman. I'll keep an eye out for Mr. Goodman. Ms. Snare.
Here.
All right. Ms. Lahan, if you can unmute and see if that works.
Am I here now?
You are here. Thank you.
Okay.
I gotcha. Dr. Gandhi, can you or Ms. Kionvang direct me? Should we go to item 14C? I think the rest are scheduled for 10 o'clock, right?
Correct. And we can even go into my report as a filler or deputy report if we still have time.
Okay.
14C was Elevate RX. Are they here from Elevate?
Do we have anyone present from Elevate RX?
They weren't responsive yesterday, Madam Chair, but
Ms. Walmsley, this is Sharon Richardson.
Yes, Ms.
I
Richardson.
did make a phone attempt and an email attempt to contact them, and I've had no response.
Thank you, Ms. Richardson. Appreciate that. Board members, just a reminder from yesterday, this is a non-resident pharmacy application. There were some questions about the services they offer and some missing information regarding their policies and procedures. How would we like to, they've been non-responsive to the board's request, the staff's request regarding the information. How would we like to handle this circumstance? I think our options were either to table it to the next meeting or to offer a hearing, correct, Miss, or to offer, yeah, I believe a hearing, right, Ms. Galvin? Those were our options from yesterday. You're muted.
this is an application, Madam Chair. Not a complaint. It's just an application for consideration.
Can we let the application close based on no response?
Expire. Based on our timelines, yeah, we would have to let it close if the timeline passes. So we could leave it in status quo. Unless they reach back out to us wanting an appearance before the board.
If we can let it close based on the time that has passed, let them reapply if they wish. I think that's, then it's off our books and we don't have to deal with it unless they reinitiate contact.
idea.
Ms. Galvin, is that appropriate?
I think that's appropriate, given their failure to respond. It would be difficult to deny because they haven't engaged in any conduct, but I think letting it close would be appropriate.
And if they provide the information, then we can hear it at the next meeting.
Correct.
Sounds good to me. Would somebody like to make a motion to that effect?
I will make the motion to that effect. Please allow the application to close based on no response, failure to respond. If they wish to reopen the application, they can contact us.
Second.
Okay.
Any further discussion? All those in favor?
Aye.
Aye. Any opposed? And Mr. Goodman, have you joined us now?
Yes, I logged in and got on probably maybe a couple seconds after roll call. I wasn't sure if there was a roll
Okay.
call because it was something like 9:47.
Okay, perfect. I just wanted to make sure we had you noted for the minutes. Thank you.
Thank you.
All right. We still have a few minutes. Dr. Gandhi, do you have a suggestion of which report we take?
Yes, Madam Chair.
Where would you like to go next?
I can start mine, Madam Chair, and I can stop in an event we want to move to another agenda item, but yeah, I can continue with my report and get that out of the way if you're okay with that.
Yep, that sounds good. So item 28, discussion and determination for possible actions. 28A is the executive director's report. We have a number of items here. So 28A1, update and follow up on the board's prior asks.
Just get my notes organized. Give me 1 second. In prior meetings, there were several asks by board members. So I'm just going to go down the list of what I have, and we'll continue to add in the future meetings. The first one was technician duties. I know that board staff, along with board members, have drafted language that was directed by the governor's office, and AZPA was involved as well. And we came to an agreement with language that was then handed off to AZPA and Kelly's group to have a discussion with the Medical Association per the direction from the governor's office. From my understanding, I touched base with Kelly this morning, and she had tried to connect with the Medical Association prior to session, but was unable to do so. She'll continue to try, but that's where it is right now. The governor's office is not wavering of our ask, is not going to approve our ask until the Medical Association is okay with the language. So that's where that sits right now. So it is out of our hands and in the association's hands right now. Notes from previous agenda items being carried over previous agenda item to the next new board book. It is a systems, it's the diligence software system that doesn't allow it for today, but there's also, and Ms. Galvin, if you can chime in on that. I believe there may be some concerns about meeting notes being transferred from previous agenda items to when that agenda item is carried over to the next meeting and so forth. Am I correct, incorrect? Is that allowable?
Yes, I know that some members had requested that. And if their notes transfer from one meeting to another, then that would be appropriate. It's just reminders to them about previous thoughts when the matter was first reviewed.
So we can certainly entertain that discussion with diligent and see if that's capable to do when we move an agenda item. When we recreate an agenda, it is recreating an agenda on our end. And when we publish the book, it wipes everything clean. From my understanding, it just isn't a cut and paste process. So we'll take it up with the vendor and see if that's possible. Having you guys have individual accounts.
Yeah, yep. Go ahead, Mo.
Sir, Dr. Gandy, I understand how the notes get wiped out when something gets removed and gets put into the archives. Do we control how soon the items from previous meetings have to be removed from the main menu? Can we not just remove the previous board meetings for a couple of cycles?
Let me find out for you, Mr. Solari.
Okay, that
We
may
do
be a
have an
workaround.
archive folder.
Yeah, so you're
Yeah.
saying just keep those meetings in the system so that you could go back and look at it without having to, because they're gone after the meeting.
Well, they go into the archives, and into the archives, all your notes are wiped out. You can still access them, but your notes are gone. So my ask is it possible to keep them into the regular stuff so that the notes remain?
Yeah, especially since we have a
Long as-
couple of really extensive issues we're moving forward to the next meeting.
Yeah,
Correct. We will ask that of the vendor whether that's possible.
thank you.
Okay. Committee on reviewing the entire rules section in the law book. I do have that committee, the names of the committee outlined. So we'll be moving forward with that. We do have some pressing matters that we have to resolve, which I'll discuss later on in my list of topics. There were 3 agenda items: square footage of pharmacies, especially those mini hospitals and stuff, as Mr. Deng brought up, temperature of medications, DA 106 time to report. Agenda items were brought up as well. And with those topics, I think the discussion was, we need to revamp our entire rules section anyways, and we can just incorporate all those into that discussion. So that's where that is right now.
Dr. Gandhi, when do you expect that first meeting to be conducted?
I think we just got over a little bit of a hurdle right now. Later in my discussion, the Auditor General is back for their 6-month follow-up. We just submitted our report. There's going to be some follow-up to that. So I would probably still start to say mid-April is when we'll start conducting those. I have about 10 people already outlined as far as those task force members that want to participate, plus or minus a few. So digging some names out of my emails of people that have emailed me and say, hey, I want to participate. So I would anticipate around mid-April-ish is when we'll start structuring that.
Sounds good. Thank you.
Follow up on COVID immunizations. Immunizations in this state is going really well. As you can see, the age has gone down to 16. I had mine, and it was easily accessible. So I don't know if there's any other feedback from the group from what they've seen out there in the real world. But for my follow up on that is it seems to be flowing really well in this state.
I know I have tried the last couple of days to get an appointment and can't find anything anywhere, or the site's just shut down. But that's my experience.
Any other thoughts on that?
I've heard just keep checking. I do know about 4 people who were able to get in for yesterday and today.
Okay, moving on to.
In Pima County is not a problem because the university is one of the state sites, and the turnaround time is quite quick. I mean, 3 or 4 days, people have been getting in.
You recommend driving 2 hours after getting the shot, Dr. Tom? I'm just kidding.
They can stay over after the second shot. No, but if we can help out, let us know down here.
Thank you, Dr. Tom. Number 2 on my list is we had a task force meeting a couple of weeks back about regarding maintaining fingerprint clearance cards and submitting them for renewals. And there was a recommendation issued by the task force. The task force members were part of different organizations, including attorney groups representing a lot of organizations, AZPA, industry, and I think the overall appetite was not to burden the licensees. to get these fingerprint clearance cards and maintain those fingerprint clearance cards. Anything to add on that, Ms. Walmsley?
No, I think you covered it. Essentially, the recommendation was that we don't need to make any modifications to what we already do today.
And the minutes of that discussion is in the board book for your review.
Dr. Gandhi, do you need a motion on this particular agenda item since it was a follow-up to the audit?
I would like that because it was a recommendation from the task force for full board consideration.
Board members, any questions or further discussion on this item?
Me.
Anyone want to entertain a motion for Dr. Gandhi?
I am willing to make the motion to accept the recommendations of the task force.
Second.
I have a motion and a second. Any further discussion? All those in favor?
Aye.
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 Any opposed? Thank you, Dr. Gandhi. We've reached 10 o'clock. Do we want to continue on with your report or shall we move back to the?
My report shouldn't take much longer, Madam Chair. If you want me to just wrap it
Okay.
up, I certainly can.
Let's do that then.
The next topic I have is discussion of conflict of interest, and thank you everyone for submitting your conflict of interest forms. This agenda item is driven again by the Auditor General's being with us. And in essence, the statement is if there's a conflict of interest that resides within board staffs in my office here, the position would be that the other part of it is if there's a conflict of interest with a board member, then myself and the chair president will address that and may have the Attorney General, Jean Galvin or Seth Hargraves present with us to address that conflict of interest with that board member. So just wanted to put that out there, saying that's how the policy procedure is looking like. As stated earlier, next agenda item, we have the Auditor General back again to follow up on the recommendations they submitted 6 months ago. So this is their 6-month follow-up. We'll hopefully kudos and thank you to Jennifer Gilnavong, Doug and his team, and Sandy and her team for putting together a report that was just released and submitted to the Auditor General this past Tuesday. It's pretty detailed and all encompassing of the recommendations. So hopefully they won't have a lot of questions. The next follow-up from them will be in 18 months to see where we are on the remaining in progress items that they've recommended. The next agenda item is NABP District 6, 7, and 8 Planning Committee is going to resume again as we have a meeting coming up at the end of August, early September. So the time is not on our side. We are still got our pulse on the COVID situation, if there's any travel restrictions and so forth. So we'll keep an eye on for that. But we do need to get started on that. So that will resume. NABP annual meeting is taking place May 12th and 14th. It is a virtual meeting. The invitation and the registration is on NABP's website. So Madam Chair, if I may ask the board to nominate a delegate and an alternate at this time, that'd be helpful.
Yes, Dr. Gandhi, I would like to go ahead and volunteer for that. I'm planning to be present and the district's representative for the resolutions committee. So if there's no objection, I would like to go ahead and volunteer to be the delegate for the board.
I will nominate Ms. Walmsley for the delegate for the board.
Thank you, Mr. Slaughter. Thank you, Mr. Dang. And I believe we also will need an alternate.
I'm willing to serve as the alternate.
I will nominate Dr. Tong for alternate.
Thank you.
Second.
So we have an alternate and a delegate. All those in favor?
Aye.
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 I'll abstain.
Okay. The next agenda item is the requirement to collect FEIN numbers on permit applications and renewals, and requirement to collect DA registration on permit renewals. So we need board's approval for that. The FEIN is to, there's a lot of business models, different business names out there, especially with corporations. And so it allows the board staff to group them all and see who's partnered with who, and as one company. The DEA registration is more in line with the CSPMP. There is a mandate, a statute that requires all pharmacists that have a valid license in the state that works for a facility that has a DA registration to be registered with the CSPMP. Right now, we can't match up our database with the CSPMP database because we don't collect DA registration. But we need to do that based on the statutory requirement. And this is the only way to do it, is to mandate collection of that information. Any questions?
Board members, any discussion on that particular topic?
Again, these are applicable to permit holders. Pharmacists don't have DA registration.
Please remind me, educate me, what is the acronym FEIN again?
It's essence a tax ID number.
Okay, so you're going to make it mandatory when somebody applies for a permit or a renewal to provide their tax ID number and their DEA registration number?
Upon a new application, they cannot provide a DEA registration because they can't have one until they have our license. So, but we want to mandate that on renewals. The FEIN number, they should have one prior to applying to us, as that's a new business.
I see. I don't have any objection to that. That sounds reasonable.
Dr. Gandhi, do we know what other states require?
It's probably all over the board. I know that we house the PMP in our under the umbrella of the Board of Pharmacy, so we have the ability to hopefully match up the two data and see who's not registered. Other states may not have that, so there may not be a requirement for that. So I think it's all stems from the mandatory check requirement.
Dr. Gandhi, I'm not opposed to the idea of this. I just want to make sure there aren't any unintended consequences. How quickly do we need to make a decision? Renewals aren't until October, right?
That is correct, but we need to have our vendor start working on. They've asked us to submit all renewal requirements by mid-May, I believe, so that they can start coding and so forth by this renewal cycle.
Would it be possible to get stakeholder feedback? I just want to make sure there aren't any unintended consequences that those of us that don't deal with those types of renewals aren't aware of.
Sure, can certainly ask. I think we have Mr. Morris on the line as well, and we can pick his brain.
Are you comfortable? Can we do that now? Is that appropriate, Ms. Galvin? To see if anybody from the public has feedback?
You may.
Does anyone from the public have any comments on this particular suggestion from Dr. Gandhi regarding application changes for permit applications?
Hi, Madam President. Susan Trujillo from Corals and Brady. I'd be happy to provide some feedback.
Thank you, Ms. Trujillo.
It is fairly common, like Dr. Gandhi said, for state boards of pharmacy to request FEINs on applications. So, I don't think it would be problematic. And, certainly it'd be something to, if it can be on the board website ahead of time, so that it doesn't come as a surprise as people work their way through the portal that they have to provide that information. That would be helpful, just so that when the permit holder goes to access the portal and start completing, and running through all of the different fields, so that it just knows that it's out there and it needs to have that information ready.
Thank you. Appreciate that. Any additional public feedback? Dr. Gandhi, do you need a motion on this item to change the application?
Yes, I would.
I'll make a motion to change the application to add the FEIN.
In DEA number as requested by Dr. Gandhi.
Yes.
Do I have a second?
I'll second.
Thank you. I have a motion and a second. Any further discussion? All those in favor?
Aye.
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 Dr. Gandhi, I like this suggestion from Ms. Trujillo as well, to make sure that that's out there. So if we can add it to FAQs or something like that, or perhaps her newsletter coming up, I think that might be helpful for the public.
Definitely. And that's why we wanted to get this out there sooner than later so we can start communicating.
Thank you.
That's all that is on my agenda item, Madam Chair. And if you want to move to conferences or it is your
all right.
call at this point.
Yep, we'll move over to conferences. So tab 24, board members. Let's pick up.
Can I announce myself?
Who's speaking?
My name is John E. McClellan, complaint number 200473.
Mr. McClellan, we will call you at a later time.
Okay, do I have to be online here all day because I'm at my pharmacy by myself working?
Dr. Gandhi, where is his item in the agenda? I don't recall.
It is
24L is L.
24L.
It's a little way. You're actually, let's see. We are tabling items 24I and 24J, correct?
That is
Dr.
correct.
Gandhi?
That's correct.
At the request of the respondents' counsel.
Yep.
Mr. McClellan, we have one item before you. You'll be our next item after this. So hang tight.
Okay, thank you.
You're welcome. Item 24K, complaint number 20-0426, Pharmaprodia Compounding Pharmacy Group. Do we have anyone present from that organization?
Yes, I am present.
Can you please introduce yourself for the record?
Yes, my name is Richard Quenty, pharmacist in charge, Pharmaprodia Compounding Pharmacy.
Thank you, Mr. Quinty. Is your technician, Ms. Valletta, joining us today as well?
Yes, she is on her cell phone. Yes, she is in the conference.
Ms. Valletta, can you please introduce yourself for the record, please? You're muted, ma'am.
Sorry. Hello, my name is Danielle Valletta. I am Richard Quenty's technician.
Thank you, appreciate it. Ms. Richardson, I believe you were the complaints officer for this complaint. Can you please give us a brief recap?
Yes, ma'am. This is a complaint in which the patient stated that she had filled a prescription at Pharmaprodia Compounding for a troche formulation of a hormone combination. She had filled this prescription many times, but this was the first time that she had filled it at this particular pharmacy. In her complaint, she stated that she pointed out to the pharmacist that it could not be for a cream and that he had responded to her, "I don't know if I can make this." She stated that the troches that she did receive in the end were hard, brittle, and difficult to remove from the box, that she had to use a knife, and that they were actually hard enough to deform the box when removing them, causing them to break apart when they were removed. She stated that all of her previous fills of this prescription from the previous pharmacy had been flexible. I visited the pharmacy on 10/21 of 2020. I found Mr. Pharmacist Quente in the lobby talking with the receptionist. We went into the pharmacy together, and I did observe technician Danielle Valletta working in the compounding room. I do not know what tasks she was performing at that time, but she was in the compounding room. After presenting the complaint to pharmacist Quinte, I asked to see a copy of the prescription, including any documentation, the compounding record, formulation record, and equipment used. I have included a copy in your packet for your reference, a copy of the phoned-in prescription, the compounding record that I obtained. In reviewing the record, the calculations do appear to be correct. The compounding record is missing the prescription number, and there's no indication of any quality control procedure that was conducted. But again, it appears based on the record that all the calculations that were used were correct. The compounding record did list a formula ID. However, there was no formulation record available. This would be the document that shows how the compound is specifically made by the pharmacy, including ingredients and quantities, equipment, mixing instructions, temperatures, in this case for melting the base of the troche, duration of mixing, containers and closures for dispensing, and any quality control procedures. I did ask Mr. Quinte for the formulation record. He went online and printed a formulation from Letco Med of a similar compound that would need to be adjusted for the appropriate strength for this prescription. While this is an appropriate reference, it's not the record for his prescriptions, showing how it was compounded by this pharmacy, as it was just available online. It wasn't tied to this prescription. I asked where his formulation records were kept, and he stated that this is what they use. I told him I was looking for the record specific to his prescriptions tied to the prescription numbers in the batches. Again, referred me back to the same compounding record. I did ask to see what information he had on file for the prescription. Some pharmacies do have their master formulations in the computer, and you can easily tie them back to that prescription. He did state that this was a new computer system and he no longer has that information for those prescriptions. The computer only has prescription dispensing data in it. No compounding records were linked to the prescription. So it's unclear what the formula ID on the compounding record that he provided refers to. I did inform him he is required to keep all of these records on file for 7 years, regardless of whether he changes to a new system. Based on that, he did provide me, combined with Ms. Valletta's statement, that they printed the Letco Med sample formula, followed it according to SOPs, but I'm not certain that the pharmacy keeps the formulation record as required. I did include that reference from Letco Med in your packet. Again, the compounding record calculations appear to be consistent. The reference he provided does use a base that includes bitter block. He used a base that did not, and then added a bitterness suppressor liquid later. It's unclear if that change in base or adding additional liquid would have an effect on the formulation, but it is different than the reference that he provided to support the formula. I then asked to see the training records for his technician, Ms. Valletta. The training book that he presented to me contained commonly requested GI compounds and select formulations from Spectrum. There was no technician training included in the book. Mr. Quinte could not provide me any documentation of completion of training for Ms. Valletta. Ms. Valletta did say in her statement that she was undergoing training, that she performed everything under his supervision or watching him, that she makes no changes to formula records, et cetera. However, there was no documentation of that training. I did inform Mr. Quinte that pharmacy technicians cannot compound until they have completed a compounding training program. Ms. Valletta does state that she measured the ingredients under the supervision. She also states that we printed and followed according to standard operating procedures and guidelines, referring to the sample formula. She states that she has taken part in making creams, troches, capsules, ODTs, mouthwashes, etc. I have also included for you the pharmacy SOP on checking a compounded prescription, which outlines the technician making the compound, placing it and the ingredients in a bin for pharmacist checking. It does not call for a pharmacist to verify any measurements or weights. In this case, we have verified calculations on the compounding record, but no formulation record to show what was made and measured, nor verification of those weights and measures. Pharmacist Quinte does state that he currently makes all the compounds with the assistance of his technician. Again, this requires technician training. Again, in addition to on my arrival, as I mentioned, he was in the lobby visiting with a receptionist employee, and Ms. Valletta was in the pharmacy alone in the compounding room at that time. And that is all I have, unless you have additional questions for me.
Thank you, Ms. Richardson. Board members, any questions for Ms. Richardson? Mr. Quinty, would you care to make a brief statement before we proceed with questions?
Yes. The facts of this allegation are completely misconstrued. And I want to go ahead and recap actually what happened, because the patient complaint was full of a lot of lies and misstatements. Okay. So first of all, I've prepared a brief statement I want to read. This complaint was from a disgruntled woman who used every textbook definition of incivility, almost to the point of pressuring me to take orders from her to genuinely change a prescription from a troche. The prescription was initially called for a cream, and I documented and presented a copy of that prescription to Ms. Richardson when she came. The prescription was for a cream. So when she came to pick up the prescription, she said, no, she's never used a troche. I said, well, the prescription that was called into the pharmacy was for a hormonal cream. And that's exactly what we meant. So she wanted me to automatically change it to a cream. I said, unfortunately, ma'am, that's not how we operate. I have to have that order clarified from the physician for me to change it from a cream to a troche. She was very, very unhappy with that, okay? So the fact that the lady said she presented a troche, I said, it's impossible to do with that did not happen. Nothing ever happened. First of all, this lady, Ms. Richardson told me that this lady wanted to be anonymous, okay? This is not a complaint that she wanted to be, she wanted to be part of. She wanted the complaint to be investigated, but she didn't want to be part of the complaint, okay? So first of all, I was told by the inspector the day of the inspection that Ms. Cynthia Fair wanted to be anonymous. She wanted an investigation, but did not want to be part of the investigation. She was in fact forced to be part of this investigation. Okay, so it all started when I got a call from Ms. Cynthia Fair's physician assistant for a month's supply for a hormonal cream.
Mr.
Yes.
Quinty, sorry to interrupt you, but please refrain from using the HIPAA information for the patient. Please either refer to her as the patient or use initials.
Okay.
Thank you.
Yeah. So the patient's physician assistant called in a 1 month supply for a cream. Yes, the prescription was initially called in for a hormone cream and was later changed to a troche. I gave the inspector both hard copies. Both telephone transcribed orders were 100% complete. The prescription was properly filled as a cream and patient was called for pickup. It was during prescription pickup that patient refused the cream and told me he had never used the cream before, that the doctor was supposed to call in a prescription for a troche. That was not dosage form called that was called. I explained it to her that and even showed her the hard copy of the call-in prescription. She was almost compelling me to make the troche the same day and to make sure I add a bitterness suppressor, something that she never discussed. I did not have a bitterness suppressor as in stock and had to place an immediate order to the company. I told her, unfortunately, I would need to call physician for prescription change from cream to troche. Patient had no legal right to ask me as a pharmacist to change the form of the prescription that was called. Minor changes such as flavors could be accommodated, but not a major change in dosage form. She was very upset. She asked for a refund and we refunded her. and told her to come the following Tuesday to pick up the trochee. It was during this time that I placed the order. Okay. So the trochee was made with all approved ingredients and approved NDC numbers, and patient was called to pick up the prescription. During pickup, she never complained about anything. Her temper flare up from the last meeting seemed to have calmed down a little. I never heard from Miss Cynthia Fair until the Board of Pharmacy showed up. So she said her trochees were hard and brittle. Okay? This is a trochee base from Letco Medical. It's hard solid at room temperature. Trochee base are supposed to be melted and formulated into a trochee. So how, when a physician called in a prescription for a trochee, there was no mention of what type of trochee is supposed to be made. There are basically two different kinds of trochees. One is a gelatin gum trochee, which are very soft and while the other is a polyethylene glycol trochee. So this is the one we made because the doctor never specified what trochee should be made for her, okay? So let me delve a little bit into the heart of the inspector's report to put some clarity on some of the allegations. We do keep any and all formulation records as required. Ms. Richardson came when our pharmacy was 3 weeks into a new cloud-based system that was developed to do any and all prescription records kept on the cloud, online. Logging to the system was IP specific. So she came, the day she came, we couldn't log into the system. I even presented proof of that through an email that I sent to the director of the Board of Pharmacy, Dr. Kam Gandhi, and a copy to Ms. Richardson. So we couldn't log into the cloud-based system for me to show her the process because she kept asking for a database of our formulas, and that's where we store all the database of our formulas. But she never believed anything I was trying to explain to her. I forwarded an email, with proof of that to Ms. Richardson and the executive director. Secondly, the inspector report does not mention anything about the wrong prescription call into the provider's medical assistant. The prescription was initially called in wrong. It was called in for a cream instead of a trochee, and we made a trochee. But I'm surprised that the whole report, including what the inspector wrote, never mentioned anything about the wrong prescription call in. Thirdly, the inspector mentions meeting Daniel Valletta working in the pharmacy unsupervised without mentioning what she was doing. She was cleaning dishes. The whole day we did nothing. And even in the email copy that I sent to the executive director, the whole day she came, we didn't do any production, okay? So she said Daniel was in the pharmacy working while I was in the lobby. It's totally misconstrued. It's not correct because that whole day we didn't work. And also the standard operating procedures for making trochee is very consistent for each particular type of trochee. This is almost same for 99% of cases. If patient's trochee did not have the attached instructions, this was because we made this trochee for this patient on September 9. That was almost at the time when we were transferring from the old system to a new cloud-based system. The cloud-based system is new. It was developed by PCCA to reduce paperwork. That way, everything, every prescription, every batch record, every formula could be stored in the cloud that could easily be retrieved anywhere at any particular time. So when she came, when we had no access to be able to, to log into the system. And there was no way for me to even show her because she didn't believe anything I said. So I presented her the basic information, including the batch record with the calculations, a copy of the sample formula from Letco Medical, all that information we presented to her. So,
Mr. Quinty?
Yes.
Yeah, I have a question for you, and I want to try to help this along a little bit. I hear what you're saying, and I'm not as necessarily hung up on the preparation of the trochee. That's not my main concern here because I have looked at that. And in my opinion, I'm more concerned about the record keeping. Now, whether you're in a new system or you're in an old system, it's your requirement to be able to produce that record keeping when asked by an agency that governs your pharmacy. So you couldn't that day. I get it. There's times that stuff happens. You couldn't that day. But were you able to submit that information at a later date to Ms. Richardson?
The record keeping for the trochees? Yes.
So the record keeping and the record of the training for the technician and the formulation record.
Yes, I have all the trick. Ms. Richardson came when Daniel Valletta was 3 weeks on the job. So she never took part in any preparation without she was merely watching me do, so during the time she came, all her training records were not put in place together, okay? Because the policy is that when we hire a new employee, you work for about 3 months, then we compile that training documentation. We have a file for her. Yes, currently right now we have a full and complete file containing all the training records.
Thank you.
Appreciate that. Ms. Richardson, were you able to receive any of the missing record keeping after your visit?
No, sir.
Okay, thank you.
Sir,
yes,
are you saying that Ms. Valletta only watched you and was trained through observation, or did she take part in any of the compounding?
Yeah, she took part in some of the compounding. After she has been proficient for a couple of months. I actually have a technician who worked here for 3 months, a licensed technician that could testify to the board that she worked here for 3 months and she never took part in any production. She was watching me. She would co-sign my weighings and everything. I act as a pharmacist technician, production.
So Mr. Quinty, thank you. I think the question is, did Ms. Valletta participate in compounding before she was fully trained and the training was documented?
No, the patient's trochee was actually made, we made them together, okay? Because yes, I understand that technicians have to be trained before they can make products, but technicians have to take part in production under supervision, because it's how does somebody become fully a proficient in whatever they're doing without actually taking part? Because there's no way I'm going to let her just watch me doing capsules without her actually participating in capsule making. So I teach her within the first couple of weeks, then later on, we do it together. I watch her do it, until she becomes very proficient. Then she passes a testing, which is both oral and written. And I have all that information documented in her training.
Thank you.
Madam Chair, this is Cam.
Yes, go ahead.
I just want to put on record that Ms. Richardson's testimony that she provided was not her testimony, but a lot of the investigation discussion she's had with the technician as well as the pharmacist. So for Mr. Nwenti to say Ms. Richardson didn't believe her or insinuated that he's lying or whatever the fact of it is, These are things that were observed. Even to this day, we don't have those records, as he stated himself. So I'm finding this this testimony Mr. Wente is stating against Ms. Richardson as a little bit harsh, and stating that she's I guess malicious, right, going after him.
No,
Which
no, it's not.
Which is kind of
Mr. Wente, please don't interrupt Dr. Gandhi. You'll have a chance to speak.
So I mean, I just wanted to add that for the record. I think Ms. Richardson's testimony is neutral, and the facts are the facts.
Thank you. Board members, additional questions for
Madam
either for Mr. Wente or Ms. Richardson?
Madam Chair.
Yes.
Ms. Valletta, can you hear me?
Yes, I can hear you.
Okay, thank you. Can you tell me a little bit about your training and what part was hands-on, what part was actual learning in the books, and was it documented? And just tell me in your own words, the timing of that and what you want me to know about that, okay?
Okay.
Thank you.
Yeah. The first few weeks I was just observing, just watching him. After that, I started with him, first checking him do the weights. And then after I was, like he says, proficient and knowing my measurements, then I started doing measurements with him. So it was gradually going up like that. Again, after I did the measurements though, I didn't take part in the actual of mixing it. He would do that. And I would just help him fill like the molds maybe, if anything, but that was already, what is it? Like I was already like two, maybe 3 months in already by that time. So the only things I was doing when they came to inspect was just doing the measurements. And then gradually, like I said, I started doing more. I did have to take a written test with him that we took part in, and it's just going over like questions of everything that we do here. Procedures, the temperatures that things should be in and all that. I did take a test and then I did pass it. We have the records of that here. And yeah, I mean, is there anything else I can answer for you?
No, thank you. That was a good explanation. On the day of this incident, were you washing dishes?
Yes, I was. I even stopped. I was in the, as soon as because I was in here washing the dishes while he was in the reception. And then I heard Miss Richard, I heard them talking and coming this way. And so then I stopped to see what was going on. And then we came back in here into the room. And I actually stopped just so I could give them the room because they were using the room to look for the papers and everything that they were discussing. But yes, I was washing dishes that day. And it was just dishes that were like equipment. I was just washing equipment.
Thank you, Ms. Valletta. Madam Chair, it's my opinion that where we're going with this is we still have a violation of good record compounding and record keeping. I'm not 100% sure on the technician training if there's any record keeping on that. I'm hearing that there is. I just heard from Ms. Valletta. I'd be willing to let that go in good faith, but I do think that we have a problem with the record keeping. If there isn't today, there was at the time of that incident, and that's where I would recommend we go as a board.
I agree with you. I do have one additional question for Ms. Valletta about procedurally after reading the policies and procedures that Mr. Quinte submitted. Ms. Valletta, when you prepare compounds, you mentioned that you were involved in the weighing and things like that, and obviously are still doing that. Does the pharmacist verify the quantities of the various ingredients before they're prepared?
Yes, he's in the room with me the whole time. I don't make anything alone still. He's still with me here. As I'm doing it, he's checking me.
So he signs off on each step of the compound?
On each thing, he still to this day signs off on everything.
Okay, thank you.
Yeah.
I appreciate that.
Yeah.
Board members, additional questions or discussion?
Madam President, I
Yes,
have a
go ahead.
question for Mr. Richard Quinte. So Mr. Quinte, you mentioned that when the physician sent you the orders for the medications, he or she did not specify what type of troche that he would like you to compound. As a pharmacist, wouldn't it make sense that you would call out, make a phone call to the physician and clarify? with a physician, the type of troche that he would like you to compound?
With that particular troche, 99% of the time when a physician calls in an order for a troche, it's for a polyethylene glycol troche. But the remaining 1% of cases, they are gelatin-based troches. And most often, when they ask for a troche, it's for a polyethylene glycol troche. So yes, we didn't ask what kind of troche they wanted.
I mean, in fairness, many physicians do not know the component of the drug. It is our job as a drug specialist to educate them. So I hate to say this, but it is your fault for not clarifying with a physician. So that's all I have.
Just to bring the discussion back, I agree with Dr. Leba. I mean, compounding is certainly an art, and there's a lot of science that goes behind it, and the formulations are very individualized. I think really what's before us today and the areas that we've identified are some record keeping gaps with the compounding records, the inability for Mr. Quinty to provide the compounding formulations related to the specific prescriptions in question, and then the related compounding training. Any additional discussion, or are we ready to have a potential motion here?
Ms. Walmsley, I don't have anything else. I've heard everybody thoroughly. I think we have a violation of compounding record keeping on that day. Now, it may be different today, but on that day when Ms. Richardson went in, I do believe her account, and I think that should be a letter of concern to this pharmacy.
I second that.
And that's to the pharmacy or pharmacists?
To Mr. Quinty is the pick. So I would think that he would be the one that was in control of the record keeping, and that's the route I would go, but I am open to hearing a different opinion.
Mr. Quinty, you're also the owner, right?
I have a question, yes. Yes, I am the owner. I have a question. The formula record for this prescription, everything was complete. And based on Board of Pharmacy rules, electronic copies of batch records are acceptable. They are acceptable part of the medical of the prescription batch record.
Thank you.
Mr. Quinty, we're at the point of discussion. I'm going to go ahead and the board members are going to continue to discuss this. Ms. Richardson has reviewed the records. The board members have reviewed the records and don't feel that they meet the requirements. We have a motion on the floor for a letter of concern to either Mr. Quinty or to the permit. Dr. Leba.
I feel that the PIC.
Ms. Nair, you were the second in agreement?
Yes, that's fine.
Okay, thank you. Additional discussion, board members.
Ma'am, is this the kind of thing that would require reinspection just to make sure the records are being kept properly, that the training records are now in order? Just thinking out loud, perhaps a reinspection is in order at Mr. Quinty's expense to go make sure everything is done correctly.
Mr. Slory, Madam Chair.
Yes, go ahead.
To Mr. Slory's point, we might be able to get the same outcome if proof of record keeping is submitted. Just an idea, Mr. Slory, because
I agree.
if he is really telling us he can produce those, then there shouldn't be a problem producing those.
And just for Mr. Quinty, the motion here is a letter of concern. This is a non-disciplinary action. Essentially just stating that we had concerns with your record keeping at the point of the inspection.
I am willing to amend to Madam Chair to amend to Mr. Slory good point that proof of the correct procedures for record keeping is submitted to Ms. Richardson
And training.
and training.
Training.
I would amend my second.
Ms. Galvin, since it's a non-disciplinary letter, is that acceptable, or do you need anything additional there?
I think that's fine. We can note in the letter of concern or the administrative letter that they would request proof of the record keeping corrections made, the procedures with respect to compounding and training.
Okay, thank you.
If those records are not what the board staff finds sufficient, we'll bring it back to you.
Perfect.
Thank you. Any additional discussion, board members? Hearing none, all those in favor?
Aye.
Aye. Any opposed? Thank you, Mr. Quinty and Ms. Valletta, for your time today. You'll be receiving the documentation from the board. Again, this is a non-disciplinary letter of concern.
All right, thank you so much.
Thank you.
I want to apologize to Ms. Richardson if I sounded as if she didn't believe me. It's because of basically a lot of what the lady, the patient said was all false. They were all false.
Thank you,
Yes.
Thank you, Mr. Quinty. We appreciate that, but for the purpose of time, we need to move on. Appreciate that apology.
Thank you so much.
Thank you. Moving on to item.
May I speak?
Who is this? I'm sorry.
Dina Sosa. I'm not sure, but we had a case today and I'm just getting information that it may have been postponed, but I didn't hear anything about it.
Dr. Gandhi, can you clarify, please?
Ms. Walmsley, this is Sharon Richardson. She was involved in item 24I.
Okay, thank you. Yes, Ms. Sosa, that item has been continued to the next meeting.
Okay, and do we know when that is? Are we going to get like some kind of email or?
Yes, you'll receive an additional notice from the board staff that the meeting is the beginning of May, I believe the 4th and 5th, but you'll receive a specific notice for that.
Okay, thank you so much.
Thank you.
Bye-bye.
Item 24L, complaint number 20-0473, the Apothecary Pharmacy. Do we have anyone present from the apothecary?
Yes, John McClellan.
Thank you, Mr. McClellan. Can you please state your position with the pharmacy?
I'm the owner, pharmacist for 26 years.
And you're the pharmacist in charge as well?
Yes.
Thank you. Ms. Richardson, I believe you're the compliance officer for this case as well. Can you please provide a brief recap?
Yes, ma'am. A complaint was received from an employee of a nurse practitioner's office stating that a patient's alprazolam prescription was being refilled early by pharmacist McClellan. The complainant stated that the patient reported that their prescription had been stolen on November 7th of 2020, and the medical assistant or secretary, whatever she may be, from the doctor's office called the pharmacy to ask for a refill for the patient. She was told by the pharmacist that he could not fill it as it had just been refilled on October 20th, and then refilled again for cash on November 3rd. The complainant states that she was told by the pharmacist that he filled it early because the patient's prescription was stolen the week prior, and he gave the patient the benefit of the doubt. We did run a dispensing report through the pdmp for the period of 6/1 of 2019 through 12/14 of 2020. 2 dispensings in the pharmacy record do not appear on the pdmp report where we compared them. So on 6/8 of 2020 and 9/23 of 19, 2 fills for the alprazolam were indicated in the pharmacy.
Richardson, can you pause just for a second? Sure. Ms. Crystal, is it possible that you can mute Mr. Quinty's line? There's a lot of background noise. And I think his line is unmuted. Go ahead and proceed, Ms. Richardson.
Sure. So again, on the PDMP report that we pulled compared to the pharmacy records, there were 2 missing fills that did not appear on the PDMP report. According to the PDMP report, the prescription has only been filled for this patient at this pharmacy. For the time period that we reviewed, the prescription was filled early 50% of the time. That would be 9 out of 18 fills. The prescription is for 120 alprazolam tablets for a 30-day supply. I did include the PDMP report for your reference. And in my summary, I've also included a summary of the early refills for you. I can outline those if you would like, but again, it's 50% of the time they are filled early. There are a couple that are probably of note from 6/4 of 19 to 6/20 of 19. There were a total of 3 fills for 360 tablets filled in 16 days. That one is probably the one that stands out the most in that history. If you'd like me to review all of the fill notes from the summary, just let me know. I was not able to personally visit with Mr. McClellan when I drove out to the town where he's located at. He was closed on that day, but I was able to communicate with him and notify him of the complaint via email. And he did provide a statement, which is included in your packet as well. He stated that he did fill the prescription early on November 3rd when the patient came into town to vote. He did not mention anything of a stolen prescription. He indicated that the prescriber did not indicate that the prescriptions could only be filled on certain dates, and that it was sometimes filled early for the patient's convenience. There was no documentation provided of any communication between the pharmacy and the prescriber before the early fills. The prescriber has since canceled all further refills on the prescription, and at the time of the writing of this report, it had not been filled since November 3rd.
Thank you, Ms. Richardson. Mr. McClellan, would you care to make a brief opening statement?
Ms. Walmsley, can I ask a question of Ms. Richardson real quick before the statement,
Yes.
or do I need to
Yeah,
share?
no, go ahead. Thank you.
Okay. Did the pharmacist, to your knowledge, add any refills to the prescriptions, or were they all legitimate prescribed?
I believe they were all legitimately prescribed. There's no indication of him adding anything.
Thank you.
Mr. McClellan?
Yes. This is.
Go ahead.
This patient is somewhat a special needs patient. He's got a lot of medical conditions. He now lives in a senior citizen home in Lake Havasu City. And his various medicines come due different times of the month. And so I used professional judgment to do early fills on this so I could get him with his other medications. I never, ever added any additional fills other than what the nurse practitioner prescribed, and they were all within the time frame until the next telephonic appointment that the patient had. The patient has never had an in-person appointment with this nurse practitioner because they're based in Tucson or Yuma, and it's through a behavioral health unit. And I've had no contact with behavioral health or with the nurse practitioner that prescribed these since he told me to cancel all additional refills.
Ms. Richardson, I have a question for you. So I understand that this complaint was regarding one particular patient. Did you look at any other patients while you were there?
No, I did not, because I was not able to actually visit the pharmacy. It was closed the day that I was there. The pharmacy is located in Parker.
Okay.
So after arriving and it was closed, then I simply communicated him via email.
Okay. Board members, any additional questions for Ms. Richardson or Mr. McClellan?
Madam Chair, this is Kevin.
Go ahead.
So I have a question for Pharmacist McClellan. You mentioned that you use your clinical judgment to make the decision with all the early fills, but looking at the PDMP report in 16 days, you had filled 360 tablets of the razapam. There's a large quantities. 360 tablets in 16 days, 300 for 1, 2, 3, 4 drugs. That to me, that doesn't make sense. When you mentioned you were using your clinical judgment, that doesn't justify the clinical judgment usage.
You're probably right on that one.
So how do you explain that to us?
I particularly don't remember that, but it might have been one of the times when he had medications stolen, supposedly. And I tried to believe him.
Well, you can't really convince me on that one.
Okay, I agree. I had bad judgment there.
Ms. Richardson, during your investigation on this particular patient, correct me if I'm wrong, but you found 2 records of controlled substance dispensings that were not included in the patient's prescription drug monitoring report, correct?
Yes, ma'am, that's correct. There were 2 dispensings in the pharmacy record, one from June 8th of 2020, one from September 23rd of 2019 that did not appear in the PDMP report that we ran in December.
Mr. McClellan, can you explain how these prescriptions are missing from the controlled substance monitoring system for this patient? How do your records in your pharmacy get over into the system? How does that work?
This is the first time I've been notified of 2 missing records. So I submit my controlled substances, every day at the end of the day that I dispense any controlled substances.
So how do you submit those? Explain that process to us, please.
My software prints out a file for me and I transmit it electronically to the controlled substance website.
You transmit that directly for each patient yourself?
No, it does a bulk transmission of all controlled substance for that day.
Okay. Board members, additional questions?
I have a question.
Go ahead.
Mr. McClellan, are you still practicing as a pharmacist?
Yes, I am.
And can you explain, you're stating what was the reason you were doing it? Because it was early. I've heard theft. You did them early for this patient because I've heard you say that maybe kind of a special needs patient and possibly theft at some point. But what other reasons did you do it early? Because you did it multiple times. I'm just curious.
Well, he's living 45 miles away. He's on multiple medications that come due at different times. And for convenience sake.
Okay, so I'm not sure that convenience sake makes sense to me when there's so many fills that are close together.
All right, I agree. That was poor judgment.
Mr. McClellan, go ahead, Dr. Solari.
I just wanted to say something. I'm looking at the PDMP report, which is on page 2867 and 2866. And although there is early refills, there is 12 fills in a 12-month period. So I can understand his point. A patient is coming into town for 45 miles. He wants to get a prescription, some other prescription filled. He might as well pick up this one a little bit early. The pharmacist did not exceed the total of 12 fills in 12 months, even though they were not necessarily filled at a close to a month period, is the way I'm seeing the PDMP report. I guess part of patient care, like he says, is patient convenience and accommodating long-term customers or patients. And I'm from my way of thinking, I'm having a tough time faulting him for that, even though he didn't follow the letter of the law or he didn't exercise the best judgment in his own words. you know, it's not that egregious a violation to fill a little early as long as you don't exceed the total number of refills in the total year. So I'm just sharing my thoughts with you on that.
Well,
Madam Chair.
Go ahead, Mr. Leba.
Ms. Richardson, can you respond to that comment? Because I'm looking, I see what he's saying, but I'm looking at your notes at the bottom, and I'm seeing from 6/4 to 6/20, there were 360
Busy on
tablets
a conference call right now.
dispensed. And then I'm seeing 11/12 to 12/18, 360, 2/4 to 3/2, 360. This is egregious. So it is a big deal, but and it's negligence. So can you confirm that that is accurate and these are indeed missing from the PMP?
There are only 2 of them, Mr. Leba, that are missing from the PMP. What we do have is, as you said, there were 3 fills in 16 days for a total of 360 tablets. From 11/12 of 19 to 12/18 of 19, there were 3 fills for a total of 360 tablets in a 36-day time period. From 2/4 of 20 to 3/2, there was a total of 360 tablets dispensed in 27 days. From 7/22 to 8/12, there were 3 fills in 21 days. And again, each of those fills is written as a 30-day supply. And the reason I include that for your reference is typically if a prescriber is okay with a patient having a large quantity filled that lasts through their next appointment, they would typically dispense the large quantity. They wouldn't write a smaller quantity plus refills. It's usually the intent of the prescriber to have it filled 30 days at a time. They don't always give specific dates for fill. But in this case, it would be inferred that they wanted 30 days plus additional refills.
So then, Mr. Solari, I'm hearing a different story on that. I'm not sure why the PMP is not telling the same story, but I'm hearing a very different story. I'm also hearing, you know, Mr. McClellan talks about, you know, they live 45 minutes plus away. They never met the prescriber, never talked to the prescriber. Prescriber is in Tucson or Yuma. These are all what you call red flags. They're literally red flags in dispensing and require a little bit more attention. In a rural area, there can be scenarios that happen like that. But in combination of dispensing early, Ms. Richardson, was there any documentation on the scripts of a consult with the prescriber prior to dispensing 360 tablets in a 6-day period, for instance, in the first statement on the summary?
I wasn't in there, Mr. Leba, and I don't have any documentation provided by Mr. McClellan to indicate any authorizations to fill early. The complainant, being the doctor's office, seemed surprised that it had been filled early. So again, I don't have documentation one way or the other. I kind of inferred from Mr. McClellan's statement and the complainant that there hadn't been a request and permission to fill early. To Mr. Solari's point, when you do calculate these out, he did not get more in the 12-month period because Mr. McClellan didn't add additional refills or anything like that. He would take one legitimate prescription that was written for 1 plus, say, 2 or 3 refills, but he would compress and fill that 3 months worth of refills into a period of 16 days, which I don't believe was the prescriber's intent.
Madam Chair, so another red flag that caught my attention is on page 2867. On 6/4/2019, 30-day supply of alprazolam was filled and it was adjudicated through the patient's insurance. The 2 subsequent fills were private pays. And then not until August 20th, the fill on that at that time was adjudicated through the insurance. So that gives me a feeling that these private pays were illegal to some aspect. some sort of
Is
fraudulent.
that when they were stolen, Mr. McClellan? When he had his meds stolen?
That might have been. I can't remember back that far now.
But then, Mr. McClellan, as a pharmacist, if a patient comes to you and say, okay, my narcotics has been stolen, immediately you would have advised the patient to contact the police, to get the police report, to document the theft of the medication. Make sense? You would just say, okay, you lost your narcotics. Here you go. I'm gonna give you another refill. And then 10 days later, patient call you and say, okay, I lost my narcotic. And then you can say, all right, let me give you another refill. That is just not the right way for us to conduct business, especially with the narcotics.
Yes, I agree with you at this point. I was wrong.
Mr. McClellan, do you make it a regular practice to document the reason for early fills on the prescription?
No, I don't.
Do you make it a practice to fill controlled substances early? What is your typical practice for filling controlled substances for patients?
Usually 5 to 7 days early.
Consistently?
Well, depending on when the doctor presents the new scripts. See, these were controlled for alprazolam, which you can put refills on. On the opioids, there's no refills. But if the doctor sends me a script 5 to 7 days early, and the doctor says that one's okay to fill, I fill it.
Ms. Richardson, did you have a comment you wanted to make?
Yes, I just wanted to address what Mr. Dang said. The ones that were run through as private pay, so there were a total of 10 on the screen print that we have from the pharmacy record. 10 of those prescriptions were not run on insurance and they were paid for as cash. I just wanted to point out, I don't think there was any fraudulent activity there. I just believe that it was too soon on the insurance. It rejected because obviously 3 refills in 16 days, they're going to reject. So I think that's where you're seeing the cash pay, where the insurance flagged it as being a too soon of a refill. And Mr. McClellan decided to fill it and allowed the patient to pay cash for it.
Right. And I only charged him $8 for the prescriptions for a fill. And his normal insurance was $3.60. So I'm not doing it to make a profit of any great amount.
Mr. McClellan, do you offer this to other patients? Are you doing this for other patients as well?
Sometimes on non-controlled substances, a patient wants to pay cash.
I think we're probably more concerned with something that is a controlled substance.
Right. No, I don't make it a habit all the time.
Mr. McClellan, as a result of this complaint and this investigation, what have you learned? What changes are you going to make to your practice?
I've got to be much more careful on early fills of controlled substances.
Does that mean, what are you going to do? Give us some examples of, more checking with physicians, more prescribers, give us a little.
Yes, I need to, if it's going to have to be early, I'm going to have to check with the prescriber and I'm going to have to document it on the prescription.
Mr. McClellan, had you done that on any of these early fills?
No, I had not.
Mr. McClellan, are you familiar with the term corresponding responsibility?
Not exactly.
Are you familiar with the DEA red flags that Mr. Leyba referred to earlier today?
Yeah, I think so.
As a pharmacist, you have a responsibility to ensure that controlled substances are written and dispensed for legitimate medical purposes. That's your responsibility by the DEA. That's your responsibility here in the state of Arizona. My concern is that it doesn't sound like on a regular basis here that you are really perhaps following all the steps of corresponding responsibility. You know, you're filling prescriptions early, using cash payments. Patients are coming from long distances. There could be question of whether or not the patient has a valid patient-prescriber relationship here. I have significant concerns with some of your practices here and whether or not you're really dispensing prescriptions in the manner in which we would expect of you, as well as the DEA. I think that there certainly is some education perhaps that needs to be done here by Mr. McClellan regarding some of that responsibility. And that's kind of where my head is starting with here, starting to potentially think about formulating a motion. But I do have concerns about the legitimacy of some of these prescriptions perhaps that he's filling.
Well, this nurse practitioner with behavioral health, this behavioral health has changed ownership at least 4 times in the past several years. And this patient just automatically got the new prescriber each time. But the behavioral health satellite office is local here. And that's where the gal that I assume was secretary is the one that red flagged this.
Thank you. Board members, additional questions or discussion here?
Madam Chair, I share your concerns, and I agree with you that continuing education here is warranted. So I'm in support of that. I think some continuing education in controlled substance law is warranted. Perhaps a non-disciplinary letter of concern is warranted. So I'm willing to go in that direction once I hear from other board members.
Well, in my opinion, I agree with you about the education piece, but because we're dealing with the controlled substances, I'm more leaning towards the disciplinary concern, letter of concern.
Oh, Jesus.
In this case, Dr. Dang, oh, sorry, Nick, go ahead.
No, please continue.
Yeah, in this case, I don't think he exceeded the total number of refills allowed. The patient was certainly not harmed. I don't think there's any issues with diversion. So I'm willing to be more lenient and not do discipline. That's my thoughts.
I personally disagree with you there, Mr. Solari. I don't think we know we didn't know the extent of his practice. Ms. Richardson was not able to visit there, so she didn't perform a controlled substance audit. To me, there are more issues that are here. We still haven't even addressed the failure to report to the controlled substance monitoring program, which could, result in additional fillings at other pharmacies because people aren't aware of those things. I think that there could be potentially a lot more issues here. So I disagree with the thought that it should be non-disciplinary. I think there needs to be some sort of discipline here so that there is a record of it. I'm don't have a strong opinion yet on exactly what that should be. I'd like to continue to hear from other board members. Mr. Goodman, did you have something to add?
Yes, I'm with you that in light of today's information, that definitely there should be something happen on a disciplinary down that track. I also believe that we need to do a much broader investigation. There are many things that have been brought up in today's discussion with the pharmacist that create considerable red flags of how are things being managed and what's the patient safety like. You guys, of course, as pharmacists and as people embedded in the industry know much better, but I'm hearing these things and I'm thinking most anybody can go in and get their prescription filled whenever they want. And that's not how pharmacology works, or at least not how it works in modern day.
Thank you, Mr. Goodman.
Madam Chair.
Yes.
Hearing this, I always go back to in industry, what would a reasonable standard pharmacist do? And regardless of the time frame, looking at the amount dispensed in specific segments of that year is negligent. There's no other way to say it. It's negligent. When I first looked at it, I thought maybe this was negligence at making money at the cost of addiction. I don't think it was about making money now. I think it was carelessness. The answers that I'm hearing do not lead me to believe that he's thought much about this since it happened, nor is he very educated in the red flags and substance abuse, in my opinion. We have a huge governor's opioid plan in place, and so many red flags have popped up here. I do believe with Mr. Goodman that there could be other things. We don't know that. I think there should be disciplinary continuing education. And, you know, in my notes, I have 12 hours of CE and substance abuse and addiction therapy. And then I have a year of probation. Somebody could have been very hurt here by these actions.
Madam Chair.
Yes, go ahead, Mr. Deng.
I concur with Mr. Leyba. And in addition to that, and I still think that we should have our compliance officer, Ms. Richardson, to go back to that pharmacy and conduct more audits on the dispensing of controlled substances to other patients. I would like to see the pattern of how pharmacist John McClellan dispensed controlled substances to other patients. From then, we can see whether or not there's some underlying activity going on at his pharmacy. But that's just my thought.
Thank you, Mr. Deng.
Madam Chair, can I speak for a moment?
Yes, go ahead.
I agree with Mo. I think he made a mistake. I think continuing education always helps in every case. I think anything over a letter of concern, I think is fine. Anything over that, I think is over the top. So I would be more in favor of doing a letter of concern and some type of educational piece in order to take care of this. Thank you.
May I add one other piece?
Yes, go ahead.
You know, I'm going to turn to, I use this term affectionately, not to be disrespectful, but there's aspects to being a small town pharmacist that you have to respect. He knows his patients. He knows their life situation. Sometimes you make judgment calls based on how you know, what you know about your patient. I believe this is one of those cases where an elderly patient with multiple issues comes into the pharmacy, doesn't want to drive the long distance. I don't know how many other pharmacies are available to this patient. And he made a judgment call based on his relationship with the patient, try to help this patient. I understand everything Dr. Leyba and Dr. Dang said. They are right, but you know, the small town pharmacy practice is a little bit different, in my opinion, based on the individuals and the relationships. And so, you know, that's how I feel about this. I don't think he was particularly negligent in that way. I think he practices pharmacy in a small town environment. So I'm willing to cut him some slack with that and let him, you know, take care of his patients.
Mr. Dang.
Agree with Mo.
Okay, so one last rebuttal, and this is from as a resident of the state. We all know that patients do shop around for controlled substances. My fear is just by looking at this dispensing pattern, the patient's gonna go around and say, that pharmacy is so easy. I'm able to get a large quantity of controlled substances filled. And guess what? More and more patients, through word of mouth, they're gonna keep going to his pharmacy because they know that he is not very strict with dispensing controlled substances in a legal way. So I don't want to send a message to our state or residents that this particular pharmacy, the guideline is very lenient when it comes to refilling controlled substances. So that's my fear in terms of patient safety.
I agree. Mr. Solari, I've worked in both small town and very large towns, and you get to know your patients regardless of the surrounding area that you currently live in. You might see them more often around town or know them personally, but you get to know your patients and care for them the same. So I don't know if I buy into that idea, but I wanted to comment on Mr. Leyba. I would be in favor of probation. I'm just curious if we don't have terms that of value, then probation wouldn't be of value. So if he's not going to be able to be the pick of his own pharmacy, that would be a hefty term. But I'm just curious what terms you had in mind and what you think would be of value to include in the terms.
Thanks, Ms. Nara. And I was putting it out there as a talking discussion. I go back again. Your standard pharmacist, hometown, not hometown, wouldn't have done that. It's dangerous, especially everything that we've gone through in our communities. It's dangerous. I think 12 hours of CE and learning is needed. I'm hearing a lot of learning that is needed. I do not feel that it should be a letter of concern. I'm here to tell you, I've been around and I've seen dispensing patterns, and this is not one of them. This is not a good one. It really is not. I think I could stray from the probation with a follow-up inspection and the 12 hours of CE in substance abuse and addiction therapy. But I won't be able to vote for a non-disciplinary with an act like this, whether it's hometown or not. And then hearing Mr. McClellan, I'm sure he's a great guy, but I don't think that serves the residents of Parker very well, especially in this case, when it comes to narcotic dispensing.
I agree.
I agree with you. I think that there needs to be some form of discipline. I still would like to learn more about the general practice there. I mean, granted, this is one patient that we're looking at here, so I think probation is probably a little bit too far. And just throwing out there an alternative, it seems like we have two pretty wide varying views here. Perhaps we look at tabling this discussion until the next meeting and have Ms. Richardson make a visit to the pharmacy and look into the additional practices, conduct a controlled substance audit, see if this is a one-off, what does the overall practice look like, and then perhaps that will allow us to make a better decision moving forward and make sure that this truly is not just a one-off.
Madam Chair, if I may interject.
Yes.
And if there's an imminent threat to the public upon our investigation, we do have the option of calling an emergency meeting to address that concern. But I mean, like you said, we're on polar opposites here, and I think there's an appetite to dive in a little deeper to see what's going on further in that operation.
Well, and I'm concerned that, there could be prescribers that are prescribing medications if there are things that are additional things that are not being reported to the controlled substance monitoring program, where there could really be some patient harm out there. So I feel like I would like a little bit more information personally before we can make a clear decision. And that's a great point that we can call an emergency meeting if we feel like there's an imminent threat upon Ms. Richardson's visit to the pharmacy. But I'm certainly open to other opinions, just throwing it out there as an option.
Yeah, this is good.
I would support that.
So
go ahead.
Not as a desire to be a contrarian, I don't think that we have to put these things at opposition. We can act today and investigate. And I would much prefer that given the level of concern, given the feedback from the pharmacist of things that he admits that one, he should have done better, and things he admits that he does as some regular course, we should act today and investigate.
I agree with that. That's what I was going to say. We can act on what we know now, and we can act again if there's further concern later.
Agree.
How quickly can we do the inspection, the follow-up? Can we put a time saying it's got to be done within the next week? Is that possible with the staff with the inspection?
Ms. Richardson?
Yes.
If we could have a window that's very immediate.
We can coordinate that, Dr. Tong.
Yes, I'm able to go. And I will take Elizabeth with me. Elizabeth will be taking over that territory, so it'll be a good training opportunity. So the two of us will go together.
Okay, you're okay with that? Okay, thank you.
Madam Chair, if I may make a comment and ask Ms. Gallagher, Mr. Hargraves a question. If the board adjudicates this complaint today, The matters in this complaint cannot really be, it's a double jeopardy situation, is it not? You can't reopen and rehash this complaint again.
If you were to resolve this matter today, it relates to this particular patient, the early refills, et cetera. Then if you go up and conduct an investigation and find that there's a pattern involving additional patients, different controlled substances, then you could open a new complaint.
But once we make a adjudication today, and let's say we do disciplinary CE or whatever, later we find more stuff, are you going to assign more CE? I mean, I guess I agree with what I see Mr. Goodman and Ms. Snare's point, but I guess if we're going to make a decision, let's have all the facts and make one decision based on all the facts rather than multiple decisions based on multiple facts. I'd rather wait for Ms. Richardson's report before we decide. There's no rush to decision here. Nothing is going to change.
Well, Mr. Solari, if we find that there's a wrongful pattern going on, then we can proceed with probation.
Yes, but let's say the opposite. Ms. Richardson goes and finds that everything is perfect, and this was just a one-off. Now, can you go back and take back? I don't know. I guess I'd just rather have all the facts and make one decision rather than make a decision now and then add to it later, or not, and then be remorseful that we did something we shouldn't.
This is Goodman. Might the compromise here be to do the strongest letter of concern that's non-disciplinary today and open the investigation to have it done within a week? Then we can address today to say, look, this is a big deal. From what we know, we are rather concerned. And then we do the investigation. If we need the emergency meeting because much greater measures are needed, we can. If it doesn't need to be emergent, it could be the next meeting and allow the course to continue.
Madam Chair, my opinion on that is, so just forget everything in the future, what we're going to do. What we have in front of us today, in my opinion, is disciplinary. I'm prepared to act on disciplinary without probation, and then the inspection can be looked at later. But no matter how you look at it, in my opinion, we need some disciplinary continuing education to send a message in this case. That's just my opinion. I also do not think that there's harm in letting Ms. Richardson within 10, 14 days complete a inspection and report back.
Maybe we should make a motion and see if it passes or fails.
Yeah,
at this point.
that's what I was going to say. So do I have a motion?
Is that a motion, Mr. Labor?
So right now, if I was to be forced to make a motion, this would be it. I make a motion that we allow Ms. Richardson's within 14 days to complete an inspection at Mr. McClellan's pharmacy, and then we come back as a board and review.
I second that.
Okay.
Is the inspection at Mr. McClellan's cost, or?
Yes.
We haven't found any.
Which would require a consent agreement.
We haven't found any violations at this point, so I would recommend that the inspection be conducted at the board's expense. It's still investigatory.
Okay. So
Can we restate the motion before we vote?
Yes, thank you.
The motion would be to not take action on the underlying complaint at this point, but request that the compliance officers conduct an inspection at the facility within 14 days and then report back to the board at a future meeting. And if, implicit in that is if it needs to be an emergency meeting, we will do that.
Yes.
Did I have a second for that?
I will second that, as long as inspection is all we're doing. I'll second that.
Okay. Any further discussion? Dr. Gandhi, go ahead and do a roll call, just because I don't know if it's going to be unanimous here.
Certainly. Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leva?
Aye.
Lahan?
Aye.
Ms. Wamsley?
Aye.
Tom?
Aye.
can't come up there right now. I'm online
Goodman?
with a video conference.
No.
Ms. Nair.
Thank you.
Nay.
Ayes have it, Madam Chair.
Ayes have it. So, Mr. McClellan, thank you for your time today. The compliance officers, this complaint is being tabled for this meeting and will be discussed at a future meeting. The compliance officers will be coming out for a visit to you.
All right. Thank you very much for your time and your advice.
Thank you, Mr.
I appreciate it. Thank you for your time today. All right. Item 24M. Ms. Nair, can you take this item for me? I'm recused due to my employment.
And,
Yes, we actually were just sent information regarding this because we didn't have the full information. So if we could take it after lunch.
Okay.
So we
do
have
we
time
want
to review.
do we want to move on to 24N or do we want to take lunch now?
Lunch.
Madam President, I have to leave before 1 o'clock today, so I will be missing the meeting.
Okay.
Thank
Okay,
you.
so perhaps we should go ahead and proceed with one more agenda item while we've got Dr. Tong. And then we'll break for lunch after the next agenda item. So let's move on to 24N, complaint number 20-0498, Optum Pharmacy. Do we have anyone present from Optum Pharmacy?
Roger Morris, counsel for Optum, and you should have the two pharmacists that you requested here, Chris and Sean. They
This is
can
Chris
introduce
Griffin.
themselves.
I'm the pharmacist in charge of the Optum 801 site.
Thank you.
Hi, Madam President. This is Sean Bjorndal from the Carlsbad Pharmacy, pharmacist in charge.
Thank you.
Madam Chair, we were notified by Mr. Morris that he's going to be representing on this case this morning. So
Okay.
On record.
No problem. We're free to proceed, Ms. Galvin?
Yes, you are.
Madam
Okay.
Chair,
Yes.
Ms. Galvin and Mr. Morris, I do believe I worked with Sean in the past. Is that true, Sean, or am I?
No, yes, I saw you and I'm like, I haven't seen you in 7 or 8 years. It's been a while, Joe. Nice to see you.
Yes, it's been a while, and I just want to disclose that. If you would like me to recuse, I have no problem doing that. It will not affect my judgment, but I did want to come forward with that.
No, I'm fine.
And we have no objection with Mr. Leba remaining on.
Ms. Galvin, are you okay?
Yes, I am.
Okay, thank you.
Thank you, Mr. Leba, for that. Ms. Richardson, I believe you're the compliance officer for this case as well. Can you please provide a brief summary?
Yes, ma'am. All right. This complaint was filed by the patient's husband on her behalf, alleging that a pharmacy had incorrectly filled a prescription for Tagrisso 40 milligrams with the 80 milligram strength. The patient had been filling this prescription for the 40 milligrams regularly at Optum Pharmacy. In August of 2020, a refill request was made by the pharmacy to the prescriber as it was out of refills. It is unclear if the refill request was for the Tagrisso 40. It appears that it was, but the prescription that came back was written for the 80 milligrams to take a half a tablet a day. According to the pharmacy records, a second and third request was made for the refill on August 6th and August 10th, as they had not heard back from the physician. On August 11th, a new prescription was received. Again, that was for the 80 milligram with directions to take 1/2 tablet daily. The complainant mentions in his statement that the pharmacy told him that they were out of stock of the 40 milligram tablets. In discussion with Chris Griffey, who's the PIC, that was not the case. The particular pharmacy that prescription was sent to does not carry that strength, and so they call it medication access, and perhaps the patient was confused by medication access and not having it in stock. So they forwarded it to the correct location at Optum that uses that medication. Again, I didn't obtain any documentation showing that the pharmacy requested this change at all. It appears to have come directly from the doctor that way. Mr. Griffey does state that he doesn't have a record of any conversation with the patient or the prescriber to change the medication. On December 28th, I did leave a message for the prescriber's office to see if they had any record of a communication. I didn't receive a call back, so I was not able to determine any origin in that sense. On August 11th, when that prescription was received, the pharmacist performing data verification DUR, which occurs under Sean's location in California, they do have a shared services agreement. He held up the prescription, that particular pharmacist held it up with a note saying that he wanted to verify the change to the 80 milligram and also that the medication should not be cut in half. On August 12th, a copy of that prescription written on 8/11 was forwarded to the pharmacy from a different Optum location. It was not able to be determined what department or what location that prescription came from. The required information for transferring a prescription was not on there. It was simply forwarded. It appears via fax. It could have been electronic. I'm not sure, but in any case, it does not indicate in that forwarding record where it came from, pharmacist names. It wasn't done as a transfer. A different pharmacist then received that prescription. The original one that was being held up by the first pharmacist for verification was canceled and deactivated, and this new prescription was then filled in its place. The pharmacist who obtained this prescription and did the DUR and verification on it was different than that original pharmacist, and they did not hold it up for any clarification. On August 13th, a pharmacy care coordinator called the patient to set up delivery. They spoke with the patient's husband and reviewed the new prescription and new directions. No pharmacist was consulted at that point. Mr. Griffey was able to show documentation that yes, indeed, that conversation occurred. It doesn't appear that there was any concern on the complainant's behalf at that time when it was discussed with the patient. We did have a previous complaint regarding the pharmacy care coordinators, and I'll just point out again, those are not pharmacy techs or pharmacists, but we did resolve the issue with their job description. So you're going to see a job description included in this complaint. That was prior to the additional information that Mr. Morris was able to provide us last time about what that job description actually entails. So just point that out to you that I don't think the job description is an issue at this point. The complainant stated that he called the pharmacy after he received the medication, spoke to a representative about receiving the incorrect strength. He was not transferred to a pharmacist. He states that the representative told him that the pharmacist said to just cut them in half. Again, Mr. Griffey did research that for us. He was not able to find any documentation, whether a voice recording or notes in the system that conversation actually occurred. The complainant, who is a retired physician, didn't think that it sounded right to cut that in half. So he did contact the local pharmacy where he's at. The pharmacist there told him that indeed they should not be split into half. He then contacted Optum, asked to return the medication. And according to Mr. Griffey, there is a record of that and a return was processed.
Thank you, Ms. Richardson. Mr. Morris, would you like to make a brief opening statement, or somebody else from Optum?
Sure. I believe the opening statement is we are in 100% agreement with everything Ms. Richardson said. That's there. It was a prescription for 80 milligram to cut in half, following the request by the pharmacy 3 different times to the physician's office for a refill authorization for the 40 milligram tablet. They got 2 different times 80 milligram half from the doctor's office. Ultimately, the pharmacist who was responsible for the live prescription decided that was okay and allowed it to proceed, and it was dispensed to the patient. Patient's husband was unhappy with it. They accepted it back, gave him a refund to be able to deal with this. It's a customer service issue, but it's not a pharmacy issue that's here. Mr. Griffey and Mr. Borgman can both answer any questions that anyone has if you'd like.
Thank you, Mr. Morris. Board members, questions for Ms. Richardson or Mr. Morris or the others from Optum?
I have a question about the note process. A note was sent from one pharmacist to the other, but it didn't carry over as it went from one pharmacy to the next. Is that the case?
So the note was attached to the first prescription we received for the 80 milligrams. Once the second one came in, the system prompted the technician typing it up that there was already a prescription in process for that same drug and strength, and offers them the option to deactivate the one in process and continue with the newest one. So she chose that option. Once that original one was deactivated, then that note that was attached with it gets deactivated with it. It does not get passed on to the, that's just how our system works. It does not get passed on to the next script.
Okay, yeah, that makes sense. Thank you.
Madam Chair. Yeah, Mr. Griffey or Mr. Brunel, I don't know the answer to this. I'm not setting you up. I don't know the answer to this. There are in industries certain drugs that even if they're time release, you do have the ability to cut them in half. Is this drug, should it not be cut in half? Had the doctor ordered it before to be cut in half and it was the standard for this prescriber and the patient?
We didn't see anything else on this on this patient's profile of them receiving an 80 milligram with directions to cut it in half. They had been on 80 milligrams, a full tablet, over a year ago, and that had been decreased to the 40. They had never had a prescription asking to cut it in half before. We've done a little bit of research during, leading up to this conference, and reached out to the drug manufacturer and looked at some other resources. The manufacturer is pretty specific about the drug not being crushed, but they say they don't have any evidence one way or another to support or not support just splitting it in half. There is also an option to dissolve the tablet in liquid and drink it. And I believe the pharmacist who verified the second prescription allowed this to go through, felt that if it could be dissolved in liquid, there was no specific instruction to not split it. And so she felt that was within her judgment to allow it to go through.
Okay. And Ms. Richardson, there was a valid script directing to do that as well.
Yes, the prescription was written 1/2 tablet.
In my opinion, then the only thing that concerns me then, Mr. Griffey, is that I can get past all that, just wanting the patient saying, and I think that we're into he said, she said here, but wanting to speak to a pharmacist and not being able to. Can you just comment on that?
Sure. Our policy is to always allow a patient to speak to a pharmacist if they request it. So if that did occur, which, like Ms. Richardson said, I went through every recorded call I could find linked to this patient's phone number, and I did not hear that. Roger and his team also transcribed those calls and reviewed them, and we could not find an instance where the patient's spouse asked to speak to a pharmacist and at all, let alone a time when he was not allowed to. But that is definitely not that is not keeping with our policy. They can speak to a pharmacist at any time they want. So, yeah, if that did occur, I don't have a record of it, and it's definitely not keeping in our policy.
Thank you.
Mm-hmm.
Doesn't look like my audio. There it goes. Thank you, Mr. Leba. Board members, any additional questions?
No, I'd be willing to make a motion if we're ready for that.
Thank you, Ms. Snare.
Make a motion to dismiss this complaint.
Second.
Second.
Any additional discussion? All those in favor?
Aye.
Aye. Any opposed? Thank you, Mr. Morris, Mr. Bjorndal, and Mr. Griffey. Appreciate your time today.
Yes, thank you for your time.
Thank you. Dr. Gandhi, if you could direct me, are we to hear 24-0 today?
24-0 was postponed, Madam Chair.
Okay.
24M is tabled till this afternoon, so you guys have a chance to read the email Ms. Jennifer Gilnavong sent out, so we can be better prepared to discuss that. We could move into special requests. It is 15 minutes before lunch, so it's at your discretion, or you can do a filler with Ms. Gilnavong's report as well. That one may not take so long.
Ms. Gilnavong's report?
Correct.
Okay, let's go there next. Ms. Gilnavong, moving to item 24B, the Deputy Director's report.
Okay. So the first item is the CO activity summary, and you will see the top violations from January and February include controlled substance audits, counseling, controlled substance record keeping, hot and cold water, and immunizations. Are there any questions before we move on?
No questions.
I don't have any.
Okay. Moving on to B2. So with this item, we wanted to bring attention to board members about a recurring situation we have when we are notified of controlled substance loss that may be due to employee theft. Often what occurs is that we are notified of the loss, possible employee pilferage, and then board staff is tasked with following up with a permit holder that notified us. And so we're trying to bring awareness to the issue and seek some guidance from board members about the best the best method to proceed, so that permit holders maybe take a more proactive approach with following up with board staff when they notify us that a theft of controlled substances may have occurred. So we are looking for your guidance on this as to how to best approach that situation.
Madam Chair?
Yes, go ahead.
Thank you for the report. And I do have a question for you. Are you only seeing this with theft, because that's what you mentioned, or is it across the board with unknown loss, with other, I mean, is it just the theft that is the one that we're saying we could have got somebody potentially off the streets from working in another pharmacy if they would have done it the right way, or is it across the board?
In terms of the follow-up to their investigation?
Yeah, well, in terms of the timeliness within the 10-day notification of discovery, right?
Well, that is a separate issue that will be addressed, but the concern is receiving, having to seek out follow-up from the permit holder regarding their investigation when theft is suspected.
Oh, okay. I think I read into it then, jumping that it was taking longer than 10 days, but you're just saying in general.
Correct.
Madam Chair, and there may be circumstances where there was an investigation completed and there was no conclusion. They didn't find any wrongdoing, maybe just issued 30 extra in error or some sort of mishap. And then it's closed on the permit holder side. And again, we're not notified that that investigation is closed. Again, it relies on board staff to follow up with these permit holders. And that becomes obviously us spinning our wheels where they could simply say, hey, just following up on this DA 106 we submitted, we didn't find anything on our end, case is closed, please close it on your end. Simple communication would resolve that, but we have it open on our end and continue to follow up repeatedly. And these are multiple occasions, not just one or two. This is why we're bringing it to your attention.
Madam Chair?
Yeah, go ahead.
Dr. Gandhi, so are they, So say you don't know, are they designating on the 106 employee theft?
They, unfortunately, they have to. The DEA changed their form. There is no other field anymore. And so it is employee pilferage or some verbiage of that nature. And so when that comes into the board office, then obviously we have to react. And if we don't react, then we're not doing our due diligence. But it's a cooperative effort with board staff and a permit holder to come to a resolution on this. If there's possible diversion that took place, but not definitive, at least let us know that is being investigated, or how did that take place? It could be an error, it could be pills dropped on the ground, whatever it may be. But again, in react to that indicated on DA 106, then board staff is negligent for not following up.
Board members, I have, in the time I've been on the board, I have never seen a case, now maybe there is one, this is my opinion, where a permit holder told the board they were doing an active investigation, they weren't sure, and the board wouldn't work with them on that. I've never seen it to where the board didn't say, okay, please keep us posted. So my opinion is you're looking for updates from employers if the case was closed, or it's been, the report has been brought to your attention and then nothing after that.
Correct. I mean, in a few instances, I think we brought it to your attention about the delays in reporting to the board about a licensee that diverted, and it took a while for us to be notified of who that was as well. And I think we addressed that with you guys in some cases. But all we're really asking for is follow through on what is taking place when they indicate that there's possible diversion that may have pilferage that took place.
I think if we were to give direction here that wasn't tied to regulation, I would say my recommendation would be for the point of contact at the board to reach out to the permit holder if they're not getting a response one time, at least, because I would say that if we reached out to, say, Kevin at his hospital, and maybe he wasn't responsible for submitting the form, but I think Kevin would give you an update. I really do. But then if there's no update, then maybe we review it as a board. I don't know what else we could tell you to do if we don't tie it with any kind of backing.
Tend to agree with you, Mr. Leyba. And, you know, a lot of times these investigations are very complicated. I've been a part of a lot of investigations in my career, and sometimes you just can't find the culprit, if you will, and it is an unknown loss. It's unfortunate that the DEA form doesn't give us the opportunity to submit it that way anymore, but wanting to make sure that, you know, we're able to fully investigate the losses and things like that. But I certainly think that communication from our licensees is certainly warranted. And if they're not cooperating with providing an update to the staff, even if it's just that we're still investigating, I do have concerns with that vein. So do you need any action from us specifically on this, Dr. Gandhi, or?
I think just direction on how many times do we have to follow up with a permit holder before we're like, you know, we're tired of chasing our tail, and bring it to your attention at that point. I mean, even after the case is closed on the permit holder side, unless we follow up with them, they don't inform us that it was closed and it was inconclusive or whatever the matter may be. So it gets a little frustrating because we have, obviously, you've seen this agenda, it's pretty packed. We're doing other things as well, and just involved with follow-up constantly is proving to be productive for this agency. So we're looking for a collaborative effort, and how do we get that is the ask.
Can I ask a question?
Yeah, go ahead.
Dr. Gandhi, when we receive the DEA forms, what's our procedure? Do we send a letter saying, or an email or something saying, hey, we received this, thank you for letting us know, or we just receive it and wait for follow-up?
I can speak to that. So it depends on the nature of the loss and the reason for the loss. And if employee pilferage is suspected, there's immediate follow-up.
So we send them a letter saying we received your thing, keep us up to date.
It really depends how much they disclose on the form or in an additional communication, what action would be taken. So if we were aware of a possible employee pilferage, we would follow up with them and ask about the status of that investigation.
And what you're saying is when you follow up with them and ask about the status of the investigation, they don't get back to you.
There are times where they do not immediately, or the investigation is ongoing and it requires periodic follow-up.
Okay.
So here's a suggestion. Perhaps could we look at changing the wording of that communication to the licensees and asking for a follow-up communication if the investigation is still ongoing every 30 days, every 14 days. I don't know what that appropriate time frame is, but perhaps at least then the permittee would know that there is an expectation of continued follow-up and not just once it's concluded, that there needs to be a more collaborative effort in between.
Jennifer, do most permits notify you if, regardless, like if it's closed? Would you say over 50% do, or just it's a problem all the way across the board?
No, there are some who notify appropriately.
For those individuals who you don't get proper follow-up, is this something that a subpoena could be used? Would that be appropriate?
I did. We haven't introduced it, but that did cross my mind. And in the subpoena, we could outline the terms of the follow-up. Obviously, we didn't want to take that aggressive action just yet. If we can have a better relationship with the permit holders and a better outcome.
But that is a tool in your toolkit, and you know, we trust your judgment. If you think you reach the point where that needs to be used, from my perspective, at least, my thoughts, don't hesitate to use it.
I agree, is that especially if there isn't responses, those types of things, but perhaps just changing that language and the earlier communications about what the expectation of the board is moving forward would be helpful. I think this conversation certainly will be helpful to the greater public to understand that this is a concern for the staff as well. Perhaps we could put something on our website or include it in our newsletter around, just more collaborative communication back and forth as well, to see if that improves the circumstances as well. Just another option.
Madam Chair. So in my opinion, the language stated under R423-1003 is very clear to all the permit holders. So if the permit holders choose not to follow the rules, then that to me is clearly they are negligent. They just refuse to follow our rules. With that in mind, can we as a board impose a customary fine of whatever, $1,000 to permit holder anytime when they fail to follow the rules and the regs that are set forth by the board pharmacy?
I think that's extreme, and this is something that's on our rule docket that we're looking at potentially changing. The discussion the last meeting, and others please jump in, was that we felt like the 10 days was perhaps not enough time to fully investigate a potential diversion circumstance. The DEA even allows longer than 10 days for a DEA investigation. So I think that might be a little bit of a heavy-handed approach to go that far that quickly. That's just my personal opinion.
I had to do this several times for my facility. I think the 10 days, that's 10 business days. So technically, the employer would have 2 weeks to conduct any investigation.
Like I said, I've participated in a lot of investigations in my career, and I think that is personally a little bit unreasonable under many circumstances.
Madam Chair.
Madam Chair.
Person. Yes.
Sorry, Mr. Lehman,
So,
but Madam Chair,
to
we
just clarify, oh,
go ahead, Mr. Lehman.
it's a clarification. I almost feel like we're talking about two different things here. There's the 10 days, and then I think Jennifer is asking for what does she do if she's not heard on a report that's already been submitted. And I think that we could, before we get to subpoena or appearance, I mean, and I don't know if you can do this, but why couldn't you issue a violation and have a response to respond within 10 days? Boom. And then if not, then you can do those other tools. But I will tell you, when I'm in the field and I see our compliance officers' notes that say respond within 10 days, it raises some eyebrows and they start to say, what am I going to say?
And you hit the nail on the head. It's not the concern about the DA 106. We understand. I've been on that side of the equation too, Madam Chair, about the investigation side. But yes, if the investigation is going to take 3, 6, a year time frame, keep us posted is what we're asking. You know, rather than us having to hound a permit holder to let us know what's going on. We also don't want to compromise the investigation that's taking place on the permit holder side by calling the store that's being investigated and tipping them off of a diversion situation, right? So us constantly following up month after month, there's a chance for us to call the store and say, hey, what's going on? We got a DA 106 from you. What's the final outcome? And obviously now your efforts as a permit holder have been blown. Our efforts to get somebody off the street may have been compromised. So it would be in everybody's best interest to have that permit holder work with us a little bit better.
I'd agree, and I don't think it's unreasonable. Maybe we could put it on the clarification that we spoke of on this one. I can't remember, Madam Chair, if a task force was formed on this, but maybe I know we talked about the language, making it more clear. Maybe there is something added for closure once the case is closed to notify the board as well.
And yeah, unfortunately, if this thought process or process continues where, again, we can't work in the same sandbox, we may have to resort to a subpoena process.
Yeah, and I agree that, I mean, that should definitely remain as a tool in the toolbox. And I think there are certainly circumstances where that would be appropriate. But I think it needs to be a case-by-case circumstance.
Correct.
So Dr. Grandi, Ms. Tianvong, do you have what you need, or do you need a motion from us on how we want to move forward?
I think we have what we need. Cam, would you agree?
I believe we do, and I know we have some leaders on our board as well as leaders watching this meeting. You can take that back, and at least we can hit the majority of the pharmacies in the state, not all, but at least that will give us some. This was a great opportunity to speak to you so that we can get the message out as well. So thank you for having that discussion.
Agree.
Appreciate that. Ms. Tianvong, do you want to move on to the next one?
Yes, so moving on to B3, continuing education audits. This is really meant to inform those licensees who may be selected for an audit of just some reminders. The first is specific to pharmacy technicians. We wanted to provide a reminder that the time frame for your continuing education hours that are required by the Board of Pharmacy is different than that which is required to maintain your certification. So those renewal cycles are not, they don't run in tandem necessarily. So we just want to remind technicians to please be mindful of that if they are audited. The second is defining the renewal cycle, and basically when a licensee, any licensee renews, the CEs that are accepted are those that are accrued during the 2-year period immediately before license renewal. So for example, if somebody were to renew on October 15th of this year, the continuing education hours that would be accepted would be from October 15th of this year back to October 15th, 2019. So we just wanted to add some clarity around that. And as a reminder, when renewal applications are submitted, the licensee is attesting to compliance with all continuing education requirements. And then finally, if a licensee is selected for an audit, we ask that all email communication be directed to ceaudit@azpharmacy.gov. That is where communication will be sent from. And we also ask that the licensee respond within the time frame specified in those email communications. Are there any questions?
Madam Chair, just a reminder, these CE audit records should be maintained for 5 years. Obviously, we have a mechanism, the CPE monitor database that houses that information. So I'd encourage everybody to register and leverage that database. But we obviously seen today that not everybody leverages that.
Excellent reminders. Thank you for that information. Board members, any additional questions there?
May I ask a question?
Yeah.
I have a procedure question. When you guys do your controlled substance audit, do you just, does the individual being audited have to be notified? Do you have the ability to just go to the CPE monitor and see if I've done my CE, and if I've done it, you say, okay, Mo, done, next? Or do you have to notify the person and get their approval or get their cooperation with the audit?
No, it's a random audit
Okay.
at this point. So no, unless we identify that Mr. Solari didn't do his CEs. If we tapped into that and you're compliant, you'd be fine. We
So you
typically
wouldn't
actually
notify me that I was
notify.
audited?
We don't go into CPE monitor. Typically, we notify Mr. Solari, have you done your CEs? Please send in your records.
And then it's up to
typically
me to go to CPE monitor, print it, and send it to you.
correct. It's our safety net that we can also check and validate that. But it would be a responsibility.
Okay. Why don't you want to do it the other way, where you just go into the CPE monitor, if you have that ability, audit the person, and if they're okay, move on?
That doesn't provide transparency. The way we inform you, hey, we're looking into your records. You are being not investigated, but you're being inquired with to provide this information. That's more transparency related.
Okay.
Again, we can always validate that information behind the scenes once we receive it from you. But we don't want to do things coherently, I guess.
Well, that's good. I appreciate that. So, okay, I just wanted to understand how the process works. Thank you.
Kim, there could be CE that's not recorded as well. So
That's
maybe
correct.
if they're very deficient, they may have a lot of proof of CE.
Yes, and at one point we didn't, our board meetings were law CEs and they're not ACPE accredited. That would not be in a CPE monitor. That would be a record that would be kept by the individual licensee.
But the CPE monitor does have the ability to upload non-ACPE accredited CEs as well. So people can use that as their source of truth and proof, and you upload the certificates and all those kinds of things so that you don't run into circumstances of papers getting misplaced or damaged or any of those kinds of things. It's a great tool, and it's been quite advanced. It's advancing, it's advanced quite a bit in my career as a pharmacist. So certainly a great tool that's out there.
One more question. Since you brought up the used to be that you got law CE when you attended the board meeting. Law CEs are no longer required per se, but it still counts as CE for us towards your 30 hours. Is there a mechanism anymore for pharmacists to join the Zoom or do something where they can get CE for continuing to for participating in a board meeting?
No, there isn't. Because the ability, the CE actually, law CE went away. There's still the ability to do law CE using appropriate sources. pharmacist letter and so forth, but not from the board's perspective.
I'm not saying because it's law CE, but it is CE. And so if I need 30 hours, and it doesn't have to be law CE, but I could attend a board meeting and get CE that Arizona recognizes. And I'm okay with it. If you want to let that program go away, that's okay by me. But I was just asking to see if that existed, or do you intend to resurrect that if we ever go back to live board meetings, or put some mechanism in place for Zoom calls?
We can definitely re-entertain that, Mr. Solari. And if I
Is
may,
it a burden? Is it extra work for you all, or a burden to the board to do that?
well, it's difficult on Zoom to obviously do that. And not everybody is given the Zoom link unless you're participating in a discussion. We have a lot of people actually watching the YouTube video, and we don't have visibility on who's doing that. Now, if we open this Zoom link up, there'd be a lot of people to track and trace to identify who's going to be speaking to what agenda item. So we're trying to contain who's on this meeting that's going to be interacting with the board. So
I would
again,
definitely not want that to go away personally. I just think it's very beneficial.
And but I don't want to see the Zoom link be provided to everyone either, because I've seen some circumstances in other states where there's been problems as well.
Agreed.
Yeah, I sense an appetite to resurrect that program once we go to live meetings.
Yes.
we can certainly entertain that, definitely. And if I may correct my statement, I was just hand slapped by some of my compliance officers about how we do stuff. So I'd like to put it on record and correct it. We do have a policy, and driven by the Auditor General, that was revised, that we do log into the CPE monitor to make sure that some folks are compliant.
Without them being notified is what you mean?
And if
Mr.
it's
Gandhi,
not,
can you repeat that? You cut out, at least on my end.
Correct.
So we do verify that people have complied with the CE requirement for licensure, random selection. And if they're not compliant, and if we don't see the number of Cs that they needed to do, then we would notify them of the missing information and then try to gather that from them.
So what I was asking is, would the person know they're being audited ahead of time? And originally you said no, but now you're saying that yes, that's actually occurring behind the scenes. And I'm okay with it. I'm not saying you're doing anything
no,
wrong.
our initial process, and this recently changed from my understanding. But in order to comply with the number of audits we have to do, we had to change our policy.
Okay.
So the licensee would not know if they were compliant. If they were not compliant, then they would know.
Okay. I just wanted to know the rules, not that I have any objection to it. Thank you, Dr. Gandhi.
Thank you.
Are there any other
May I
questions?
Sorry, I do have one question, please.
Go ahead.
When they're doing their renewal, are they attesting to that they're going to have these CEs done within the 2-year time frame, or the day that they sign that they're doing the renewal?
It's the day they do their renewal. It attests to have you completed your CEs.
Okay.
All right. Any additional questions or comments on that one? All right, go ahead, Ms. Gyeongbang.
Okay, last item in the report is the 7th Amendment to the declaration under the Public Readiness and Emergency Preparedness Act for medical countermeasures against COVID-19. This information is posted on the board's website as a resource for our licensees and the public.
Was there something in particular in the 7th Amendment to point out, or?
Ms. Walmsley, did you have a particular item that?
The reason why and this was posted at my request, the reason why I asked Jennifer to post it was based on some of the prior questions that have come in through the COVID Q&A and that have been addressed by the task force. So specifically, the 7th Amendment addresses who can supervise pharmacy interns for COVID vaccination. So this 7th Amendment allows for additional non-pharmacists to supervise pharmacy interns, physicians, physician's assistants, nurses, other medical professionals that have been trained. This is a request that we would receive from both of the colleges of pharmacy to help with the pods. So just thought it would be helpful to have it posted so that way if there were any additional questions that there was a resource.
A question. As it stands currently, we allow the CPR certification to be waived for vaccinators. Is that correct?
No.
There is a waiver for CPR if it expired. If it expired during during the course of the health emergency. If it expired prior to the health emergency, then no. But during the health emergency, we knew there was.
I just saw in here some mention about CPR being needed. Is that going to conflict with what we've got in place? It just came out as possible.
And that was my ask at the last board meeting, whether some of these waivers are still necessary, because some of these this language that's coming down from the federal level. It does indicate CPR is required, which is in conflict with our waiver request.
No, I think that's different. So the way I read it is for a new immunizer to be qualified, CPR is necessary. If you are a immunizer and you have CPR and it expires in the pandemic and you cannot go get trained or get it renewed, it covers you. But if you're new and you're going to say, Ms. Jones, sit down, I'm going to give you a shot, you do have to have a valid CPR. That's the way I interpret it.
I agree with you, and I think that we should leave the waiver in place. There's still class size restrictions with the number of new immunizers that are being trained. I think there's probably limited class availability, those kinds of things. So I certainly wouldn't want to slow down the number of immunizers that we have available in the state.
Yeah, that makes total sense. Thank you.
Madam Chair, I apologize. I didn't think those items were going to take so long.
It's
ask
okay.
a lot of questions, but I think we're a little past lunch right now. So
yes, no problem. Let's adjourn for. Let's recess for lunch. Do we want to come back at 1 o'clock or do we 1:15?
1:15, Madam Chair, if that's all right.
And to remember to do our homework at lunch.
Yes, thank you very much. So we'll return in an hour. Dr. Gandhi. Dr. Gandhi, I think the board members are all back, but if you could do a brief do a roll call just to establish the quorum.
Thank you, Madam Chair. Mr. Solari?
Yes, sir. Present.
Mr. Dang?
At your service.
Mr. Minkus? Mr. Minkus, I see his chair, but I don't see him. Mr. Leyba?
Here.
Okay, Ms. Lehan?
Present.
Ms. Walmsley? I see you, Ms. Walmsley. You're muted. Mr. Tong?
Oh, I couldn't hear you. Yes, I'm here.
Mr. Tong?
He's not returning this afternoon.
That's right. Sorry.
He had to teach this afternoon.
Mr. Goodman? Mr. Goodman. I'll keep an eye out for him. Ms. Nair?
Here.
All right. Mr. Minkus and Mr. Goodman. I'll keep an eye out for those two, Madam Chair. We still have a quorum and we can continue.
Well, the problem is going to be the next agenda item I'm recused from. So are we still going to have a quorum with the three of them missing?
Yes, we still have then five members
five.
participating. Yep. There's Mr. Reuben Minkus.
Oh, and here he comes.
Mr. Minkus.
Okay.
Mr. Minkus. Unmute, sir.
Reuben, can you hear us?
I'm here. Here.
Mr. Goodman.
All right, I'll.
Sorry about that, Cam.
Sorry, buddy.
I will turn it over to Ms. Snare for item 24.
Okay, I want to take just one quick minute. I just found out something over lunch and I wanted to address it, if you don't mind. Today is Ruben's birthday. I didn't want that day to go by. Too bad we're not together. We could all celebrate.
Thank you very much. I look forward to that day.
Happy birthday.
Happy birthday.
Thank you, guys. Thanks.
Okay, and we'll proceed now. Item 20-0258. Do we have, this is a complaint?
Madam Chair.
Oh, I'm sorry. Conference.
It's a conference and it's
Sorry.
agenda 24M for the board members. 24M is in Mark.
Okay, and respondents from Walgreens, and we have Hang Toe available.
Yes, I'm here.
Thank you. I see Mr. Hio.
Yes, respondents are here.
Okay, thank you.
Yep. I'll introduce them when you're ready.
Okay, and then Ms. Hess.
Yes.
Okay, great. Ms. Hess, do you mind starting us off with a quick introduction?
Yes, absolutely. I did go over this summary at the last meeting conference. It was tabled at that time due to an incorrect audit being loaded into the system. Mr. Hio wanted obviously a copy of the correct one, as well as all the documents that were used to conduct that audit. Understandably. I also took advantage of that time to get a written statement from Ms. Toe. I had verbal statements from her at the time, but not a written statement. And so that actually helped to shed a little bit of light to some of the statements that I have here. So quickly moving through this, unless you want me to go through this in detail, it is a little bit lengthy.
I think a quick update would be fine.
Okay, wonderful.
A quick refresh.
So yes. So the original DEA
Hold on, Carol. Mr. Hio, did you have something you wanted to say?
Yeah, yes, please. You know, that the statement from Ms. Toe wasn't shared with us, and we had, certainly requested a copy of the investigative file, beforehand, and that was part of the reason that this matter was tabled until now. So we've not received a copy of that statement. Is that something that should have been included in the file and provided to us? And I see Ms. Galvin. I don't know if she.
Yes.
Mr. Gandhi.
Trying to unmute myself. Yes, that is a statement that should have been provided. I don't know if Carol can send that over to Mr. Hio and or summarize it here.
I can definitely summarize it, Mr. Hio. I don't think there's anything in here that'll cause any surprises. There's nothing really new. The only thing is that there's a little bit of clarification regarding the as far as the reasons on one of the DEA 106s that was documented as the reason.
Ms. Snare.
And
I'm sorry to interrupt, Ms. Snare.
Yeah.
Could we see if Ms. Trujillo would like to have a copy? We could do another case. She could take a quick read on it and then we could come back.
Yeah, that you'd feel comfortable with that. Yeah. Okay. Can we get that out to Mr. Hio and then we can take another item and we'll come back to this.
Trujillo, can you confirm that you received my email? I just forwarded it to you.
Yes, I did. Thank you, Dr. Gandhi.
Okay, great. Thank you.
Cam.
Ms. Walmsley. I will hand the baton back to you.
She may have stepped away.
Oh, I'm talking on mute, huh? There is another item she's recused from if we wanted to go to do that. We could do 27D and C. If that sounds good.
Madam Chair, those two items are going to be taken separate, but they're related. 27C is, Ms. Wamsley is recused from that, but she can entertain a discussion when we get to 27D. Maybe best if we take them separately. And we do have Mr. Simcoe on the phone on the meeting here. So if we want to proceed to that, we can definitely do that.
Okay, actually, can we circle back to yesterday's discussion before we start the 27D and 27C? Mr. Solari did ask yesterday if these were connected to the remote pharmacy permits, and did we have that any clarification on whether they were or were not?
We did, and those three that were approved yesterday in remote were it is part of this discussion. So I did misspeak, and I did notify you, Ms. Snare, of that. So if we need to go back and reassess that approval, we can certainly do that.
So after the discussion, if we want to go back and discuss that again, we'll just keep that in mind. Okay, I'll go ahead and call then for 27C, which would be Walgreens. If anyone's available, they can speak on that. Looks like this is Michael. He's trying to speak. There we go.
Can you hear me?
Yeah.
Hi, Mike Simcoe, Senior Counsel, Regulatory Law with Walgreens. Thank you for taking the time today to listen to this. We have a request from the board seeking board approval. We have a number of pharmacies in a tele-pharmacy type pilot where we have pharmacists acting remotely on behalf of some of our retail pharmacies participating, where we're in a telepharmacy mode, and the pharmacist, although remains in the store, is separate outside the pharmacy and is performing the remote pharmacist functions. What we're seeking board approval for is, since these pharmacies are licensed as remote sites, they're precluded from several things. One is to perform compounding. Two is to they can't do immunizations by technicians because there's no supervising pharmacist. And the third one is having tech trainees. And since we're kind of doing this in a hybrid type pilot, there are blocks of time during the day where we are in the remote mode, and we document that on a log when we are in remote. But other big blocks of the day, the pharmacist that is remote from the pharmacy steps back into the pharmacy, and we operate as a normal retail community pharmacy with the pharmacist present inside the pharmacy. Our request is that during those periods, and only those periods of time when we're not remote and the pharmacist is inside the pharmacy supervising technicians, that we could perform compounding, that we could use technician trainees, and that under the supervision of the pharmacist, technicians would be able to provide immunizations. And again, we document the periods of time where we're remote, and we document the periods of time when the pharmacist is inside the pharmacy. And the approval we're seeking from the board is during those times when we're a traditional regular pharmacy, pharmacist present, that we could have performed those activities and have technician trainees for those periods of time. And again, this would only involve the periods of time where the pharmacist was present inside the pharmacy.
You know, I'll start off this discussion and just say that I don't see any reason why it couldn't be a hybrid model. I think the regulations and the concern is when there isn't a pharmacist in the pharmacy, but when it's a regular pharmacy, we already obviously approve of that. So I don't see anything here that's of concern to me. Maybe having a clerk that would be without supervision would be concerning, or possibly a trainee without supervision would be concerning. But those are Not really what you're proposing, from what I understand.
No. Just because of the nature of the pilot and the licensure, that those activities are precluded. But since we do have these periods of time where a pharmacist is inside the pharmacy and present, that the board would approve of us having the trainees being able to do compounding and having techs do immunization when appropriate under the supervision of the pharmacist.
So these are within Walgreens stores that already exist? Is that, or where are they going to be located? I'm sorry, can you clarify that part?
We have, I think it's 12 sites that we're doing this pilot in. And again, the pharmacist is always in the store, but during the periods of the remote pilot, the pharmacist is outside the pharmacy in a separate room, and then we're in remote mode and we behave like a remote pharmacy. But what we're asking for again is, since we're only doing this for some hours of the day, the rest of the day, the pharmacist is back inside the pharmacy and we're operating as a traditional pharmacy with the pharmacist present inside the pharmacy.
Okay. Other board members have questions?
And may I?
Yes, Mr. Solari.
Help me with the practical way this is going to get done. For example, I'm your pharmacist, so I decide, okay, now it's time for me to go be a remote pharmacist. Do I take the tech trainees and stuff with me and I make them leave the pharmacy? Then when I come back, they're allowed back in? Help me with some of those.
Sure. The way we would set it up would be there'd be a schedule of these tech trainees, but they would only be scheduled during the hours that we know we're not going to be in the remote mode. So it wouldn't necessarily be they're there, pharmacist steps out to go remote, and then we take the tech trainees out, but they would only be scheduled for those periods of time that we know we're not going to be in the remote mode, that we're going to be in the traditional pharmacy mode. But during the time we're remote, tech trainees would not be in the pharmacy.
I don't have a problem with this per se. I'm having a difficulty understanding why you'd want to even do this. If the pharmacist is present in the building, what difference does it make whether he's sitting behind in a separate room or in the pharmacy? Why do you want to differentiate that? You're still paying the guy the same amount of money. You're still, I'm not seeing the practical purpose that why you want to do this.
Yeah, I believe it had to do with the way that we had to change the licensure. And again, we're trying to emulate the remote mode. So yes, the pharmacist is in the store, but that pharmacist is not inside the pharmacy. And so during that emulation of a remote mode, those activities are not allowed.
But what is the advantage of that from a business model? Why would pharmacies want to do this? I'm not seeing it. I don't have a problem with that. I'm just not seeing the logic of why this makes sense.
Why? I'm not sure I understand the question.
So I can see if there's a remote pharmacy, the guy's somewhere else and he's monitoring the activities inside the pharmacy. But if the guy's already in the building, I don't get it.
He's not inside the pharmacy. He or she is not inside the pharmacy and not acting as a traditional pharmacist, seeing and supervising the technicians.
But he's in the building,
He's in the building, but separate, remote from the pharmacy, and using all the same technology that you would use if the pharmacists were not there at all.
Why not just put him back in the pharmacy? I'm not seeing the logic. I just
it's our test. Sure, it's our test of a telepharmacy model. But we kept the pharmacist there because we knew we were only going to do it for certain hours of the day in order to evaluate the feasibility of telepharmacy and remote pharmacy and what things we would have to do going forward if this were a model we wanted to pursue.
Okay.
So it's kind of like a test for them, right?
A pilot.
Like a test model.
You run a test for something that hasn't been done before. I'm just trying to explain this by my logic. If we know remote pharmacies are legal, if he wants to do it, he's applied for licenses and we approved it yesterday, he can do it. what's the point of the testing something that's already been done and is being done? Makes no sense to me. It doesn't need to make sense to me. I'm okay with it. I'm just saying I don't understand why this is all necessary. Just
Yeah, there's a lot of business operational and technology reasons why we want to evaluate it before we commit to doing it.
Mr. Dang?
So the question I have is, what kind of activities in particular do the pharmacists engage in when they're working remotely? What kind of activities?
They do data review, they do DUR, they do product review with the use of technology, and they do patient consultation.
So all that's are going on right now.
Correct.
And I don't see a good, an obvious reason why we would have to seclude the pharmacist from the pharmacy and put him or her in a remote area in the same building when he or she they are capable of doing the same things while they're on site in the pharmacy.
Correct. But if we're trying to evaluate a telepharmacy model, we hadn't had to emulate a telepharmacy model, and that's why we decided to remove them from the pharmacy so that we could pilot, evaluate, and understand the feasibility of telepharmacy going forward.
So, yeah, Mr. Leiba.
So the request before us is, what are we looking at? A deviation is board staff? Are we looking at a special consideration, or is this presented as a deviation?
So the telepharmacy language doesn't address the hybrid model. There's still a pharmacy. This is just a remote pharmacy, categorized as a remote pharmacy. And the pharmacist's responsibility is, of course, to do the narcotic check, I believe monthly, based on the statutes. But it doesn't address hybrid model. And that's our next topic. How does the board want to move forward with that? And then we can get into that discussion later. But this ask is to be able to be allowed to operate a telepharmacy, a remote pharmacy, part-time of the day, and then part-time act as a full-service pharmacy.
But you still have a pharmacist in the building at all times?
There's always a pharmacist in the building. There's just certain hours of the day they're not in the pharmacy, and then other hours of the day they are.
So you're basically, you have a pharmacist that's still in the building, the same duties are being done. Your pharmacist does not have direct line of sight to the pharmacy, but they do have line of sight with the technology at their fingertips, looking into the pharmacy with the paperwork that you presented.
Correct.
So are you looking to see an improvement in error rate with the pharmacist at a desk? I mean, if you compare studies of a retailer, you compare studies of a mail order, the productivity is much higher. Are you looking to look at that and say, with the pharmacist out, removed from the other duties in the pharmacy, they're able to focus on their job? What is that you're looking for? I don't have any problem with compounding, and I'm going to be honest with you, this is my opinion part here. I don't have a problem even a tech trainee working in the pharmacy when the pharmacist is out of it, but that's my opinion because they're doing the same jobs as the technicians. The immunizations I don't have a problem with because the pharmacist is there and the pharmacist will be called to duty regardless. They're in the building. Is the pharmacist in the office? Are they way away from the pharmacy, or?
There's a separate room adjacent to the pharmacy, but separate and outside the pharmacy. It's a closed room where the pharmacist is present in. And again, they're using technology just as if they were 100 miles away, with cameras that we put in and closed circuit television and technology that allows them to have, direct video with patients to do consultation, and to do product review.
Adam, may I ask a question?
Yeah, Mr. Solari.
How long do you intend to do this experiment or whatever you want to call it, proposal?
Don't know. It's still ongoing. We're still learning. I would say months, but I can't give you a definite date of when we're looking to either continue or to just end the pilot.
Okay. And then as I was reading about the technology you'll be using, on one of the pages, you had all the stuff that you're going to photographically document. I was hoping that you would add to that list lot number and expiration dates of the bottles in case of recalls and such. So that would just be my recommendation to you is part of that. Please take a photo of the lot number and expiration in case you needed to do a recall, unless you have a better way to, deal with your product recalls.
Understood. Thank you.
So I'm not hearing anyone has any big issue with this. Mr. Leyba, did you have something to add?
Yes, I do just have a question for board staff. So from what I'm hearing, I don't know why they couldn't do it other than the pharmacist will not have direct eyes into the pharmacy. They will have electronic eyes, so to speak, into the pharmacy. Is there something else that I'm missing?
Wouldn't that follow the remote pharmacy guidelines as they stand?
The remote, though, you don't have a pharmacist. In this case, you have a pharmacist. This is just a change to practice. But
instead of being like 10 miles away, they're across the store and watching the pharmacy. So it's still
I guess my point is, if they're literally adjacent to the pharmacy, are they here before us because it's just the pharmacist doesn't have direct eyes while everything's happening in there in the pharmacy? Because otherwise, I don't see why you couldn't do something like this.
Well, thank you for that. But the idea was that when we looked at remote regulations for telepharmacy, it excluded the use of trainees, it excluded compounding, and it excluded techs doing immunizations. I get it that we have a pharmacist in the store, and that's always the case. We just wanted to be sure that we had the board approval that we could perform those functions, even though we're licensed as a remote pharmacy. When there's the times of day that the pharmacist is back inside the pharmacy, that we could perform those functions.
Board staff, couldn't they do this with a regular permit?
The immunization for a technician, they can only do COVID vaccines right now based on the federal language, but it's not. It's not directly supervised, right? So this is not line of sight. They're in an isolated room. It could be adjacent. It could be across the store somewhere, but they're not directly there. So they can't directly supervise the activities that take place in the pharmacy.
So my understanding is that they are just combining two approved models. So
in essence, yes.
And I personally don't have any issue with it. I'm kind of feeling most people don't. I'm willing to make a motion.
I'm going to ask one more question. So board staff, is it a deviation or is this a new permit? I'm just confused. I'm sorry.
No, it is still classified under remote. It's just clarifying what the board, if the board wants to allow it, it's an interpretation, not a deviation request, an interpretation of the statute, whether we want to allow a hybrid model or not. And I wasn't in a position to approve it without you guys interpreting the rules.
Madam, may I?
Yes, Mr.
Why don't we do this? I get the sense that nobody has any major objection to this, but we could approve it for a certain length of time. As we always do, have them come back and give us a report of how things went. This can be not only their experiment, but our experiment as we evaluate the hybrid model. Give them whatever, 6 months, a year, whatever, to do this experiment, come back, share their results with us, share their learning, what they learned, what they failed at, whatever it was. And then that may help us with the decision of the hybrid model down the road. So,
I mean, I don't know that that's necessary, but I don't have a problem with it. Yes, Mr. Leyba?
It seems to me that if they are a remote, they are actually doing more than what's required. So to me, I feel like that's why I'm so confused if it's a deviation from an existing permit, or if you're remote, you're not really remote if you have a pharmacist there all the time. If they're going to have a pharmacist there all the time, I don't see how that's a bad thing. So I'm not alarmed with the pharmacist will get up out of that room and go check a compound. Am I correct?
No, the compounding will only occur when the pharmacist is not in the room, but actually working and present in the pharmacy.
That's what I mean. So the pharmacist would be checking a compound no matter how you look at it.
Absolutely.
The pharmacist would be working with a tech trainee or a technician if they were in a regular pharmacy. So why differentiate? Say you can't have a tech trainee. That doesn't make sense to me. And then I think you should be allowed. And then immunizations, if it's just that we're concerned as a board that there's not a pharmacist around, there is, and there's going to be a pharmacist there for any type of emergency. And would you have a policy and procedure in place? You probably do already, like most pharmacies do, if there is an event with an immunization.
Absolutely.
So I'm not hearing anything. I'm hearing more checks and balances on it than I am a true remote pharmacy.
Yeah.
Yeah.
I only brought up the tech trainee because I don't really have that big a problem. I just didn't know if it was allowed in our remote pharmacies currently. I don't know that it is.
In the remote pharmacy language, Madam Chair, is technicians and interns, not tech trainees. And so their ask is when the pharmacist is physically present and they're acting in that hybrid model to allow for tech trainees,
so that would be the deviation.
Right. So
I don't have a problem with it in this situation when it's actually in the same store. And then I wouldn't mind looking at it going forward at a remote location, but in this type of combined model, I see that it's fine. I'm going to go ahead and make a motion unless we have any other discussion.
I just would like to see this given a duration so we can learn from it as well. Have them come back in front of us with some kind of a report at some point down the road where we can evaluate where this is going.
One last comment. I do think I don't hear something that is a danger to the public here, but I would be in favor of approving and then asking for good faith for you to come back in a year and give us an update of what's going on. I don't think, Mr. Solari, I hear you, but I'm comfortable without including, because there's more stringent controls in place in this one, in my opinion. So I'm in favor of approving and asking you to come back and share what you've learned.
Absolutely.
Yeah, I'm okay with that.
And we'd be happy to return anytime the board requested, even before the year.
Okay. Mr. Leba, do you want to go ahead and make that your motion?
Yes, I'd make a motion to approve with the good faith effort of Mr. Simcoe and team coming back to present in 1 year, during a 1 year period of time. It could be 6 months or it could be 1 year. It doesn't matter to me.
I would second that. Any other discussion before we vote? All those in favor?
Aye.
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 Any opposed?
I do have one comment before Mr. Simcoe goes, just kind of a sense, an irony that I see here, and I just want to share this with the board and whoever's watching. I am no pharmacy historian by no means, but most of us know the story of Walgreens, that it was founded by Charles Walgreen in 1901, and that he was a dedicated pharmacist and believed in the role of the pharmacist in the pharmacy and doing good for the community. And I just find it ironic that a century later, the company he founded is coming back in front of us and wants to remove the pharmacist from the pharmacy. I just throw that out for a sense of irony. I wish he was around today. I would love to get his comment on where his company's headed. Just sharing that.
Okay. All right. I guess we'll move along. Thank you. Lori, if you're hearing me, do you want to go to 27D before we circle back?
Yeah, I'm here. Dr. Gandhi, do you think we sufficiently addressed those items? Then I can just recuse myself from that discussion, or Do we want to continue to discuss that?
Well, I think we kind of covered the board's position. Unless there's more questions around 27D, I think we kind
Okay.
of what
All
they're.
right, I'm good.
Are there
covered
any additional
27
questions
C
the
and
board have?
I guess not. I see 27D as a two-way thing. Can a pharmacy be a hybrid? I can't express in words what I'm thinking. How do I say this? We saw this model where the pharmacist is in the building all the time and they're working in a hybrid with a pharmacist. But can the opposite be true? Can it be a hybrid where they don't have regular hours? The pharmacist can come and go at will. They can switch back and forth anytime they felt like it. In a less structured format, would this still apply?
So, I mean, I just didn't know if you guys already addressed it. I'm happy to have a further discussion here, just as a general practice discussion, because I definitely think this impacts more than just my employer. My personal opinion here is I see no reason legally why a telepharmacy cannot act as a full pharmacy. A remote pharmacy cannot work as a full-fledged pharmacy. So you think about the types of activities that were just discussed in the last agenda item: immunizations, compounding, things like that. Those would be excluded if a pharmacist was not present in those environments. So why would we want to limit that activities from happening, especially when we're talking about remote locations in many cases? I mean, some of the prior remote pharmacies that have come in front of us, there isn't another pharmacy within many miles. And if they wanted to have a pharmacist present to do immunizations and compounding a couple of days a week, why would we want to limit that? I don't think a regular pharmacy can be a remote pharmacy because there's more stringent requirements for the controlled substance pieces and all those kinds of things, having to keep a perpetual inventory and the monthly visit and those types of things. But that's just my personal thoughts.
Yeah, can I share this from the patient's perspective? Let's say these guys, in these guys' case, they're going to post their hours. They have regular hours where, you know, they're hybrid. So they got regular hours where they're remote, and they have certain hours when they are a regular pharmacy. They're going to post that. Patients will know. Let's say I'm a pharmacy that has decides, okay, right now I want to leave. I'm going to go in the room and without posting my regular hours, decide on my own when I want to come, when I want to go. If a patient shows up, they may or may not be able to see the pharmacist. I'd like to see some structure to the hybrid model, the same way these guys proposed, as opposed to just leaving it, okay, hybrid is approved, and then somebody can do whatever the heck they want, open and close whenever they want, perform whatever services without regard to patient needs. So I'm just asking for more structure before we just say hybrid's okay.
So within the remote pharmacy law, there is a requirement that it's posted that the pharmacy has to post that there's not a pharmacist physically present. So that is already a requirement today by law. And my assumption would be if the pharmacist was present, that the patient would know that that person is a pharmacist. They would be wearing a name tag that says that they're a pharmacist.
Would those hours be regularly the same every day, every week, or can they change it at whenever they want? These guys are saying we'll post our hours certain times of the day. Routinely, we'll schedule our techs and tech trainees at certain hours of the day. What I'm saying is, without those kind of things known ahead of time, can a pharmacist just decide, okay, right now I need to go, let me make it remote, and now I'm back and feel like working, and I'm a regular pharmacy now. I'm just asking for more structure to the hybrid model than to just say, you know, hybrid's okay. Hybrid's okay can be interpreted many different ways.
It is confusing, and I think that it makes it another layer of confusing when you always have a pharmacist present. So yeah, I mean, in this case, there's always going to be a pharmacist present. The other way, Mo, that you're describing, I totally understand and get. In this case, it's you always have that pharmacist there close to the pharmacy. I I just don't
Right, but
worry
I
about
think
it
we're trying
here.
to broaden the scope and just a general discussion, since we already did the request.
Yeah.
Just in general, just in general, broadening the scope of this, how would it play out as a hybrid model? Not taking into account Walgreens.
Well, I think unless there's a rule change, you have to hear each case to see that the checks and balances are in place like in the previous case. Because I wouldn't be for it if I didn't see that they had eyes into the pharmacy, there was a plan, et cetera, et cetera.
Will that be required of a remote pharmacy anyway?
Absolutely, there's a layer.
So if they met all the regular requirements, we're not saying that they wouldn't meet the regular requirements of a remote, but a pharmacist wanted to come in on certain days like Lori proposed and offer an additional service that wouldn't be attributed to a remote pharmacy. I think that would only be benefit to the patients.
I'd agree.
And especially when remotes typically in an area that's maybe underserved, or there's a long distance to the next pharmacy. So if the pharmacists were able to come in that day, say do vaccines with the technician or something, a compound, that would only be an added bonus to the patients. So I don't see it as
MTM services, prescribing maybe in the future, those types of things.
Right.
I mean, COVID vaccines right now is a great example of what I would hope that we would see in some of these remote pharmacies that are in very, very remote areas where there isn't other healthcare providers.
It could be possibly be a staffing remedy as well.
Are we
During
talking
COVID.
about creating a brand new type of license? Just to address that, we have remote, we have a full service pharmacy. Are we now talking about having a different kind of license that somebody could apply for?
Well, and if we did that, could we
My
also have?
expectation is that they would be licensed as a remote pharmacy. Ms. Flahan?
And if we had another model, would there be a possibility that then they could also submit the hours to be open? So we'd know that there was some more structure within.
It's already required of a pharmacy.
But in the model of the hybrid,
Yeah.
for when the pharmacist would be on duty, some sort of structured hours.
Oh, of when the pharmacist would be there?
Yes.
That's what I mean by when I say from the patient standpoint, when you look at this, which is why we're all here, we want to look at it from the patient standpoint. When do you know the pharmacist is on duty, and when do you know that it's a remote? And so
if you're the patient, would you care that the pharmacist came in and did your compound overnight? You just care that it got done.
Well, no.
So you may not need
fair.
to know when they're going to pop in.
Yes. So there are times when you just want to talk to a pharmacist. Now, I have yet to be a consumer of the remote pharmacy, but during COVID, I was a consumer of telemedicine. And I can tell you, I was not a fan of telemedicine in no way. I would prefer to always be seen by a physician. I would bet you there are patients out there who do not like the telepharmacy model and would like to see the pharmacist in person. So from their perspective, it would be good to have the hours posted when there's a pharmacist there and when there's not a pharmacist there. And so in the case of the Walgreens proposal, they were going to post their hours, they were going to schedule their tech trainees, they were going to have a lot of structure there. All I'm asking is, for the patient's sake, if somebody is a remote hybrid, they need to have the hours posted that the pharmacist will be there, the hours posted that they are going to operate as a remote, so that a patient can know if they want to talk to a pharmacist in person, these are the times they can go to. And if they're okay with the remote pharmacy model, then they can do it whenever those hours are posted. I'm just trying to be thorough here, make sure we consider the licensing issue. If there's a new type of license required, we look at it from the patient's perspective. And so, if this is up for discussion, then let's think about these things.
Mo, I think if it's up for discussion, notification to the public isn't a bad idea. It isn't. What prevents a pharmacy board staff from having 2 permits? What is it that it can't happen? If you abide by the law in both, because you can have a manufacturer, you can have different permits within the same. You can have, but what is it that prevents somebody from having 2 permits in one pharmacy if they follow the law?
There's no restriction on permits, from my understanding. Obviously, if you have 2 manufacturers in one location, it kind of raises eyebrows. I think from a record keeping perspective, that can get complicating for a business model, billing issues and stuff like that, because you got 2 license numbers at one facility. So from our perspective, I think our concern is, of course, the inspection side of it. As long as the record keeping is very accurate at these hybrid models on when the pharmacist is going in and out, we'll try to figure that out from our end. From a business perspective, I think having choices may get complicating from that perspective.
So Dr. Gandhi, what do you need from us today on this agenda item? Is this enough? Do we need to have a further discussion? Do we need to, what do you need today?
Well, we'd like to know if the board's interpretation of remote allows for hybrid. And if it does, is there some sort of standardized approach, as Mr. Solari is alluding to let the patient know that I can come in between 2 p.m. and 6 p.m. because I know a pharmacist will be there, either to get my shot or whatever it may be. So I don't know if that's the direction of the board.
That is what I would like to see. I'd like to see structure so that from the patient and consumer standpoint, there's, they know what to expect. I don't want the pharmacist, especially, if it's a small operation, it's one owner. Okay, right now I feel like going, let me make it remote. And now I feel like coming back. Okay, take the remote sign off and put the regular pharmacy sign back on. I'd like to see structures. So the Walgreens model seemed rational and reasonable to me. We can look at adopting some of those things. That's why having them come back and give us a report can be valuable as we make our decisions, because we can learn from their, from their success and failures, or whatever the term is. And so before we decide, I'd like to put some structure.
So is this maybe a table discussion until we understand how the Walgreens model works?
I think so.
I agree.
And I'd like the board to consider if this hybrid model is allowed, and I'm sensing that structure is going to be encouraged and recommended, we may have to look at rules to avoid some of the concerns that I'm hearing.
My only concern in delaying this until later for the public is there are other remote pharmacies that are open today. There was a discussion about a separate company earlier. I'm not going to engage in that. But I would hate for those individuals out there to not be offering these services because they are concerned about this. Ms. Galvin, is there anything in the law that prohibits this today?
I believe what was requested in 27C is permissible. I'm not sure about 27D. I would have to look into that more carefully.
Okay.
I also wanted to make the comment. I don't think that the Walgreens, because their hybrid model is so different than what we were discussing, I just don't know that we would learn something that would be beneficial towards this idea.
My only concern, like I said, is we're in the middle of COVID right now. We have remote pharmacies that are in extremely remote parts of the state of Arizona. And are we telling those pharmacies today that the only time we would physically allow a pharmacist to be present is to do their monthly inspection, and we wouldn't want them to do immunizations if that was a service that they chose to offer that community?
That doesn't make sense.
Right.
That's my concern. And I don't want to rush anything, but I also don't want services not to be available for these remote community, for these rural communities in Arizona.
So the structure that could be put in place, it maybe some stakeholders and come up with some of that guidance from the board and the structure with that. Like it, and if the compliance officers, if a worry is how are they going to find different records, then maybe there's some guidance listed on that structure, guidance around it, just like notifying a patient if pharmacist isn't there.
Do we have the ability or the authority during the COVID and the state of emergency to allow for vaccinations at remote sites when the pharmacist, if a pharmacist is present?
Well, vaccines can technically occur anywhere as long as a pharmacist is present. There's nothing that limits that by law.
Right. So then that answers your question, doesn't it?
Well, what if they wanted to provide like a diabetic clinic where they went over medications with the patient and they just wanted to, you know, they let them know they're coming in on Monday?
Made an appointment with them to do MTM services.
Mm-hmm.
Well, that's an appointment. I don't have a problem with that. Does that come? Can they do that without even belonging to a pharmacy? Can I go out there?
Yeah.
Yeah. So I can go out there without representing my institution and provide MTM to anybody I want.
Well, and doing more. I'm sorry.
Go ahead, Ms.
Well,
Flan.
and, you know, perhaps doing more on top of what the scheduled times wouldn't be out of line, but also having those scheduled times where they know they can count on the pharmacist. And then if you make additional appointments or need to come in and do certain services, that wouldn't be excluded from that. It would just be in addition to.
And that makes sense.
I like
Ms.
that.
Galvin, is a guidance document something that could be considered here?
Like a
Or
substantive
policy?
I think that could be explored. It may be able to kind of bridge this gap. It would be more of the board's position on these types of facilities, already existing permits, not additional requirements. It's something that we could look into.
What are your thoughts, board members, on bringing this back perhaps at the next meeting for a little bit more discussion? Dr. Gandhi, I know that there are some companies out there that specialize in telepharmacy, remote pharmacy type services. Perhaps we could get some feedback from them on what's happening in other states as well.
We'll look into that, Madam Chair.
Or should it be a separate committee or task force? So we can invite other stakeholders.
I mean, I'm open to that, but I don't think there would be anything that would prohibit us from having some of those stakeholders discuss it perhaps at the next board meeting either.
This is Goodman. This is rather timely issue in that the state is about to change through House Bill, or what is it, 2454, the ability for telemedicine to happen outside of the state by basically any licensed provider in good standing in their state. And so we are going to see a lot more of these issues come about where providers are giving care in different states, making the prescriptions through combined pharmacies. So these issues are going to become much more part of our daily discussions, and then how to act in organizations like the one before. They're going to have their models to compete. So I'm very supportive of us progressing discussion on this.
Thank you, Mr. Goodman. So board member, Dr. Gandhi, do you need a motion here of some sort?
Motion or direction on, do we present it back at the May meeting? That gives people a chance to collect their thoughts and have a more robust dialogue, or task force meeting, or what would you like?
A suggestion, perhaps we could ask board staff and council to just determine that it's legal or not legal. I feel like they could do it. I feel like you could do it. And then we go from there. If it's not, I almost, there are points of this conversation, there's really good. Other points, I feel like we're making it too hard, and I think you can do it. But I would like Seth or Jean and the ED to say, this is why you can, this is why you can't. And it's a little confusing for everybody right now. My belief looking at it is it is legal. And if it's legal, then it needs to be allowed. Guidance needs to be issued on record keeping is what I'm thinking.
Board members, any additional thoughts or?
No, I agree with Mr. Leyva. Having a pharmacist present at a remote pharmacy is a positive. I just want a little structure to it, so there's some basic.
Me too.
Yeah, those kind of things.
I don't see anything wrong with that.
Exactly. So that's all we're saying is just let's decide on some basic rules and some structure, and then learn from people who are doing it like we always do and go forward.
Agreed.
Maybe we can invite someone who has a remote pharmacy to participate in the conversation.
Well, I'm thinking perhaps Telefarm or somebody like that has remote pharmacies across the country. That's kind of where my head was going. I know they've appeared in front of us before with some of the requests.
Yep.
Dr. Gandhi, is that enough for you for this meeting?
Yeah, I think we have. We'll put the pieces together.
Okay, thank you. Looking for some direction. Are we moving back to 24M or are we moving on in the agenda?
If Mr. Yu is ready to go, we can go back.
Mr. Hio?
My request at this time, unfortunately, would be to ask the board to table this matter again. Ms. To's statement, references a lot of details that I'd like a chance to review with my client, who you've actually been talking to, Mr. Simcoe here, for the past hour or so. So he hasn't had a chance to review her statement. There are others that I would want to take a look, one of whom is Matt Pruitt, who's out right now on paternity leave. I would like the chance to review her statement with my client, so that we're able to give you a fulsome response at the next board meeting.
Ms. Snare, I'll let you continue the conversation.
Okay. I'm okay with tabling. Does anybody have anything to add to that? Anything they want to object to tabling this?
Just a question for our legal counsel. Are they within their rights to request a continuation, legal counsel?
Yes, they are.
Then I don't see any choice.
Okay, I make a motion to table this.
And I'll second it based on advice from legal counsel.
Okay, all those in favor? Aye.
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 Any opposed? Okay, thank you.
Thank you.
Madam Chair, 27A. Special.
Yes. That's our next item.
Yes.
Thank you for the direction. Item 27A is, get my board book pulled back up here.
Ms. Smith.
Ms. Smith, Ms. Sherry Smith, are you present?
Yes.
Can you please introduce yourself for the record today?
My name is Shrina Smith, and
hello. Ms. Smith, can you please give us a little bit of background on your request and why you're here before us today?
well, my request was to ask the board to allow me to do an internship for Texas here in Arizona. But then Jennifer put on the table if I wanted to ask the board for relicensure. And I don't know if the board knows the rest of the story. I know Cam may know some stuff, but I don't know if the whole board knows everything. So do you want me to give you more background?
Yes.
Okay. So I was originally licensed in Texas. I moved here in '97 as a pharmacist. I stopped working in 2007 by choice, because I was working like 25 hours a week. Then I went to weekends, and I went to just 1 day a week, just Sunday only. And then I went to just not working at all. And then I tried to go back to work. It didn't work out just because of childcare, that kind of thing. And I asked the board, and I think in 2019, to come back, and that's been like over 10 years, and I hadn't been in the industry for a long time. So I petitioned to the board to see if I could be a technician because it had been so long since I had worked. And the board approved for me to be a technician. And then I tried to get a job because I had my trainee license, and with Fry's, and Fry's says, well, we want you to be certified. So then I went ahead and did a technician trainee, a technician course. I did that course. And while I was waiting for the results from the PTCB certification test, I was looking at the law for Texas, and I saw about relicensure. So then I started to get my license back. So I thought before it was too long to get my license, which is why I was trying to go the other way and be the technician to get back in the door. I started the process for relicensure, and I took the MPJE recently, and I'm waiting for the score back from the MPJE. But Texas said that if I did an internship here in Arizona, they would accept the hours. But like I said, Jennifer said, she said, if I wanted to discuss with you guys about relicensure, I wasn't at that point yet, but she put it on the table. So that was what Jennifer brought up.
Thank you, Ms. Smith. Just a couple of questions about your request and your background. So you were a licensed pharmacist in Arizona and Texas at one point in time. You graduated from a college of pharmacy, practiced as a pharmacist, but it's been since 2007 that you've practiced as a pharmacist.
That's correct.
You left the practice at that point in time.
Right.
You since have then come back into the practice, and you are working as a pharmacy technician.
I'm not working at all. I haven't worked yet.
Okay, you've not worked yet, but you have a pharmacy technician trainee license in Arizona?
That I got from the board because I wrote to the board, and the board gave me permission to step down the license. Because when it came back time to work, I thought about it, and I said, I haven't had experience in a long time. I don't think things have changed a whole lot. Pharmacy practice has changed with technology, electronic prescribing, the PMP, a lot of things have changed. And I thought, because the purpose of the board is I think about safety. I'm a safe person. And I said, well, I haven't been working for a long time. I think the best thing for me is just and plus two, before I even started working, I was only working, like I said, 1 day a week, right? And retail. So that's not much. For a long time, I worked 1 day a week. I wasn't working very much at all anyway. So I thought it was best that I became a technician first, before I became a pharmacist, just to get back into the swing of things. But when I thought about the internship, I realized, okay, being an intern, being a technician, you're pretty, with internship, there's supervision.
So sorry to interrupt you, but what is your ultimate intent here?
My ultimate intent is to work in pharmacy and be a pharmacist, but the ultimate goal is just to work safely, right? So in the pharmacy industry, that's my ultimate goal. My ultimate goal is to go ahead.
So your license lapsed in 2007. You let that go voluntarily. You haven't practiced since.
I did try to renew it, but working wasn't an option for me. I tried to work, it didn't work out. Go ahead.
Okay. But your intent is to come back into practice and work as a pharmacist here in Arizona.
Yes.
That's what the goal is.
I don't want to leave the state. I don't intend to leave the state. Right.
Okay. That's very helpful. Board members, what questions do you have for Ms. Smith?
I have a question.
Go ahead.
Board staff, Kim, could you just answer for me what is required if somebody's been out of pharmacy for an extended period of time, and what is the definition of extended period of time?
So, Mr. Leyba, to answer your question, Ms. Smith's license here in Arizona had expired in 2011. So it's been about 10 years since she's been licensed as a pharmacist in Arizona. from the information we gathered from Texas, our license had lapsed, I believe, in 2012. Is that correct, Ms. Smith?
Right.
So it's been about a good 9 years. Arizona does require that a pharmacist prove competency by, they'd have to retake the NAPLEX after 5 years of not practicing.
That's what I thought.
If they had worked in another jurisdiction as a pharmacist, they just provide us proof, and that way we can kind of bridge that experience back into Arizona. But we don't have, we have Ms. Smith not working minimum of 9 years. Well, hasn't been licensed. I don't know when she stopped working.
Yeah, working was 2007.
Yeah, so it's been considerable.
Licensing is
I think
different.
Ms. Smith's ask is to allow her to get an intern license, if I'm correct, Ms. Smith, correct? Just get some experience.
Can
Or
you
be a pharmacist.
can you repeat the statement, please? I didn't hear you.
Your intent is to ask the board to get pharmacy graduate intern license. Is that correct?
Exactly. Right. To get experience.
And then your intent is that you will take the MPJE and the NAPLEX exam at the point that you feel that you're competent to do that, and then hopefully move up and progress your practice back to a pharmacist.
My intent was not to take the NAPLEX. Your video froze. My intent was to do the internship, take the MPJE. If the board thinks, I mean, if you guys think I should take the NAPLEX, that's for you. But I know that you can get licensed without taking the NAPLEX, because who wants to take the NAPLEX all over again?
And Cam, what was it, after 10 years in Arizona, you have to take the NAPLEX?
I'm pulling up the rules right now, Mr. Leyba.
May I speak while he's looking them up? I mean,
Yes.
from when I looked at the law, I know that you guys can approve licensure if you guys think that it's feasible. Ultimately, I want you guys to do whatever you guys think is best, because it's your job to protect the public, and it's the public interest that you have at stake. But I know, I looked at the law, and from what I saw, you can be licensed without having to take NAPLEX, from my research, with board approval. And that's if you guys thought that I was competent enough to do so.
But let's, I hear you. Let's see what the actual rule is. I just want to be sure of it, because I will follow that. As far as the request to do your internship hours here for Texas, Texas has been in communication with the board, would be my guess.
Yes, Mr. Leyba.
So they're aware of it. I have no problem with that, but I would think if after, say it's 5 years in Arizona without practicing, it's internship hours and NAPLEX, that's what I would recommend you do. But whatever that guideline is how I feel.
But
I am
that's
comfortable.
my recollection.
I am comfortable with you getting intern hours here if you're communicating with Texas, but if you're to get licensed in Arizona, I'd ask you to follow the Arizona regulation on that.
I agree. I'm sorry, I'm having internet stability issues. They're working on it, and my computer crashed. Was Miss Galvin doing some research there?
Yes.
Okay.
We're both looking it up.
While they're looking it up, what you just said is true. I did see that part of the law, but there is other parts. This is a matter of what you guys want to do and what you guys think is best.
Yeah, I gave you my opinion, and that's to follow the regulation in Arizona. Now, if Texas says get your internship hours and talk to us, then that's Texas. But I don't disapprove of you getting your internship hours here for Texas either, because I think internship hours are hours. I don't think your knowledge changes when you cross the state line.
Madam Chair, her ask today is just to do the intern license. We can always research this at a future time and get back to her on that, but just to get this issue moving, are you okay with just approving, or I'm just asking, can we just approve the intern license since we're all okay with that, and then look up the regulations for a future board meeting if that becomes necessary?
I would be comfortable with that because she would have to apply for a pharmacist license, at which point we would address it. And if Texas wants to accept the hours in the meantime, that's fine too.
Yeah, there's no reason to hold up the meeting while we look things up. So I'll go ahead and make the motion to approve her to get an intern license so she can get started on accruing her hours and getting her experience.
Is there an expiration date for that?
For
a maximum time?
To get her intern license?
No, for that it would be good for.
What is the customary, is it 3 years? 4 years? Whatever the law says on that. It's been a long time since I've.
5 years.
5 years? Okay, just wanted to make sure we were all under the same understanding.
Okay.
Are you guys asking about how much time I have to get the internship hours? Is that what you're talking about?
No, how long the graduate intern license would be valid for.
Oh, I see.
Okay, so
I have 2 years. I have 2 years to finish the hours for Texas.
In Arizona, I'm told it's 5, so that's fine.
I'm good with that.
Yeah, so the motion's on the table. If anybody wants to second it and move on, we can.
I second that.
Okay,
Thank you, Dr.
have a motion and a second. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Thank you, Ms. Smith. You have been awarded your pharmacy graduate intern license. Wish you the best of luck.
Ms. Walmsley?
Yes.
Ms. Walmsley and the board, I might be mistaken, but I believe we would need Ms. Smith to apply for that license.
I thought you already had that. So yes, pending the application process and all the others, we've approved the request today.
And the reason why I came before the board is because it's a special request, because I don't meet the regular requirements.
Yes.
So you guys understand that. Okay.
Ms. Kyunvong, is there anything else you need for this? Or are you okay to move forward from there?
There's nothing else I need.
Okay, thank you. All right, you're welcome. Item 27B, Jeff DeGiorgio.
Hello, how you doing this afternoon?
Very well. Can you please introduce yourself for the record today?
Yes, full name is Jeffrey J. DeGiorgio. I'm a pharmacist with Diamond Drug in Indiana, Pennsylvania, and our pharmacy provides medication dispensing services to Maricopa County Correctional Health Services at all the county jails.
Thank you. Can you please tell us a little bit about your request today?
Yes, back in July of 2020, myself and CHS came to the board requesting a deviation to permit the use of automated dispensing machines at the county jails. And at the time, the board granted us our request, and they requested a follow-up 6 months later. So on January 13th of this year, I sent an email to Mr. Gandhi and provided an update as to the status of the project. And when we first requested our deviation, the board was concerned about replenishment of the canisters within the Insight automated dispensing cabinets. And our original deviation request was for Diamond to hire an agency or a pharmacist in Arizona to replenish the canisters, because there was a concern that correctional health services staff should not replace the canisters without the pharmacist's supervision. So in the interim, Maricopa County CHS has hired an Arizona licensed pharmacist as their pharmacist supervisor. and he and I will be working together to continue providing services to the county jails. So our question for today was, being that Maricopa County CHS now has an Arizona licensed pharmacist on staff, would he be able to be my designee to oversee the filling of the canisters in the machines? The medications will still be filled at Diamond, and we will ship those canisters to the county jail locations. But as he's a board licensed professional, would it be acceptable to him to be my designee as long as he and I work out all the policies and procedures necessary to assure accountability of all medications?
Thank you, Mr. DeGiorgio. Will you have a contract in place with either the facility or this individual?
We have a contract with Maricopa County CHS, and we also have a business associate agreement in place with them as well. So Mr. Kaler, who's the pharmacist with CHS, he's an employee of CHS. Correctional Health Services.
Would this be covered within the scope of that contract?
Yes.
Okay, thank you. Board members, additional questions for Mr. DeGiorgio? Hearing none, do we have a motion?
I make a motion to approve this request.
Do I have a second?
I'll second.
Thank you, Ms. Lehan. Any further discussion? All those in favor?
Aye.
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 Any opposed?
Goodman abstain. I missed the discussion. I got disconnected.
No problem. Thank you, Mr. Goodman. All right. Thank you, Mr. DeGiorgio. We appreciate your attendance today.
Thank you very much for hearing our deviation, and we'll continue to keep the board updated every 6 months on the progress of the project.
Appreciate that. Thank you, and best of luck to you.
All right. Be well. Thank you very much.
Thank you.
Madam Chair, if I could jump in.
Yes.
Didn't want the board members to lose sleep over the discussion that we just had. So if I could just read something to you so that it helps you guys, is if a person hasn't practiced in 5 or more years, they do have to appear before the board to furnish satisfactory proof of fitness. And typically we've looked at proof of fitness as an NAPLEX exam to show minimum competency. And that's an R423-201D.
Thank you. Appreciate that, Dr. Gandhi. Anything else?
No, they will still have to take the MPJE, and with the current rules in place, they'd have to pay all the back fees. And that'd be a considerable amount for her being expired in 2011.
Yes. I think our next agenda item is 28C.
Correct.
The CSPMP Director Report. Mr. Cicavarella, are you ready?
I am. Excuse me.
Thank you.
Well, good afternoon, board members, Madam Chair. Today, I only got 3 items I wanted to highlight about the CSPMP. And, you know, with us going through everything we have as an agency with COVID, you may or may not have known, I had lost a couple team members over the last year. And one of those team members got promoted within our agency, and that's Crystal. And that's really a fantastic accomplishment. And but one of my other team members was one of our epidemiologists. And we lost that person back in August. And recently we just got her replacement hired. And so 2 new team members. First is Jenica Wagner. She's our new administrative assistant, and her primary responsibilities are working on registrations and questions coming into the PMP. And then second of all is our epidemiologist, and her name is Zenowet Nire. And she attended school in Kansas. She finished her education in Georgia, and she has public health background while working in Atlanta. So those 2 our new team members are gonna make our department even stronger. You guys have any questions about that? All right.
I do not.
Good deal. A single board meeting does not go by without me talking a little bit about our work with integrating EHRs and the PMP into the EHR. And this is no exception. And we've been working with our vendor where we have a marketing campaign that our vendor works with EHRs that are not already integrated with the PMP. So typically when you think of the integration, most integrations aren't just like a healthcare entity, but it's the vendor, like your Cerners, your Epics, and there's many other vendors. So we have where this communication is targeting the EHR vendors themselves, because sometimes we'll hear stories about smaller healthcare entities that want to integrate, but their EHR vendor just does not take that extra step. So our campaign is geared towards both the vendors and the healthcare entities themselves. And in your packet, I gave you some examples of some of the materials that are being sent to those entities, and we're doing that in collaboration with our vendor. And then finally, I wanted to talk about our clinical alerts. So we started our clinical alerts about a year ago. We started by turning on 2 alerts. The first alert was the combination of a benzodiazepine and an opioid. And the second one was setting a threshold for potential drug-seeking behaviors. And we set the threshold if you've been to 5 prescribers and 5 pharmacies within 90 days, then there's an alert sent to both the prescribers and the pharmacists. Most recently, we turned our third alert, and that's our daily MME alert. And both prescribers and pharmacists will get alert if a patient is over the 90 MMEs. We set that 90 MME threshold with the idea that, our state law says that anything over 90 MMEs required to be written by a pain doctor. So, and we know that anything over 90 MMEs increases the chances of overdose by over 10 times. So we're kind of wanting to shout out for those using the PMP, some of those behaviors that may help healthcare practitioners make the best decisions. So I shared with you a little bit about how many alerts have been sent out, and we get feedback on it every day, and most of the feedback's very, very positive. The healthcare practitioners like that it's being pushed in front of them rather than needing to go down through the patient report to try to figure it out on if a patient's MME value is high or not. So with that, I'll just kind of stop there and ask if you guys have any questions. If not, I do want to let you guys know that next board meeting, I have an epidemiologist that works with Maricopa County, and we got some really cool work going on right now where we're sharing data between us and looking at overdose deaths and how PMP reports, I may have just said overdose deaths, but just non-fatal overdoses. And we're trying to make those look and see, from those overdoses, what did the past PMP look like? And from those that did overdose. So next board meeting, I'd like to share some of that with you guys. But for this meeting, you guys have any questions?
Thank you, Doug. Board members, any questions?
I just want to clarify on that last item you mentioned, Mr. Scavarla, are you trying to come up with a predictive tool for overdoses?
Thanks for the question, Dr. Solari. I think that my role here is I'm a houser of data. I'm a houser of data that many people never get to see. So I think the important thing for me to do is work with others within the state to make sure that we're able to use that data to the best of the ability. When we work with these other entities, it's not like PHI data. We're taking the data, doing some analytics around it to share with the state. So I don't know if that answers your question 100%, but I think the important piece is for me to highlight what we see. And we don't even know what we're going to see sometimes.
If such data exists and we can do that, that would be tremendous. And I think that's publishable material. So I commend you on that.
Thank you.
Board members, any additional questions for Mr. Scavarla? Appreciate it. Thank you.
Thank you.
Thank you.
Moving on, discussion of items to be placed on a future agenda. Board members, do we have any items?
Madam Chair.
Go ahead, Mr. Dang.
So at the last meeting, I did bring up to the board the concern that I had in regards to retail pharmacists deliberately refuse to accept written C2 prescriptions. I don't know if Dr. Gandhi has any updates on that. So if not, can we place that on the next board's meeting agenda? Dr. Gandhi? You're on mute.
Yes, we'll make note, Mr. Dang.
Okay, thank you.
Thank you. Anything additional? Dr. Gandhi, are there any remaining items outside of the call to the public?
No, I think we got it all. Let me peruse through real quick.
Yes, Dr. Leva.
I am so sorry. For future agenda item, can we go back to that? I couldn't think of it. It came to me right as we were moving on.
Okay.
Okay,
we
thank
moved
you.
on, Mr. Leva, already.
Please. I would just like a legal answer in I'll pick one county, Maricopa County. Is it legal to house compressed gas in a neighborhood? And if we had that answer, it would help me. That's all.
Thank you. I agree with you. I think that would have been very helpful for our discussion earlier in the meeting. So we're at the point for the call to the public. Crystal, can you please display the number in case anybody would like to call in, or if there's anybody that's still participating that would like to make a call to the public?
Yes, we're doing that now.
Thank
And as
you.
we're doing that, Madam Chair, I'm just going through the agenda, making sure we had not missed anything.
Thank you.
All right, we're good as far as the agenda goes, Madam Chair.
Okay. Anyone for call to the public? Crystal, have you been able to display the number? I don't see anything on my end. Oh, there it goes. We'll give it a minute then. Crystal, do we have anybody?
Madam Chair, it doesn't look like we have anybody dialed in.
Okay, then I will adjourn the meeting. Our next scheduled board meeting will be held on May 5th and 6th. Appreciate everybody's time and attendance. I know it's been a really long 2 days. Thank you, guys.
Thank you.
Madam Chair, great job.
Thank you.
Great job.
Yeah.
Bye-bye.